It was seized from the train, probably.
That is. And now, Lordship, the same statement has been given by Caesar witness 3.
And then, no point. Yes, what is that?
In fact, what happens is that they get those local people as Caesar witnesses. So one of them have, of course, said that they are from Jharkhand. And we will see the police's statement. The person who had seized, he had said that it was seized from these persons. Because police statement would suffice the entire case.
What does the letter trial court say?
Lord, judgment,
Here's the appeal.
judgment of Parliament. Judgment. Huh? Evidence level. Lordship, in FIR, the informant mentioned that there are 6-7 police personnel with them during search, but none of that police personnel were examined. It creates a doubt in entire prosecution story of recovery of ganja. And there is, Lordship, also a contradictory statement of the IO regarding the coach number.
PW4 Lordship, the in charge of the GRPS, he had said in so many terms that 3 bags were recovered from 3 persons, Suraj Kumar Roy, Bipin Roy, and so and so. Another one. Blue color trolley bag was from Suraj Kumar Roy, and the other 2 bags were from them. So they were in conscious possession.
Lordship, one more thing, Lordship. Kindly see the evidence of PW4, who was the officer who lodged the FIR, and he himself, his statement and the statement of the IO is very contradictory, Lordship, in all evidence, Lordship. A very much contradictory statement. Prima facie, there is contradiction between the IO and the informant statement. May I please, Lordship, be allowed to read the particular 2 paragraphs? IO, IO part.
We'll allow the prosecution to file the written objection.
In case of Suraj Kumar Roy, I've already prepared and I'll file it within a day or so.
Okay.
The other
Lordship, they may be allowed to file if there are objection. They may file a objection. There is a full-fledged hearing for that.
Yes, 1 week's time, because I've already prepared.
Miss S. Jahan in the IA. Miss S. Jahan, additional PP is granted a week's time to file written objection. This is the matter after.
Right, please, your lordship.
This one you write, no?
This is appeal against acquittal.
I feel like it's
This is
technical.
appeal against acquittal. The accused side is not there.
Oh, it is you.
It was only me here. Other for the accused, there are counsels.
Okay, this is, you are for the other side.
No,
Yes.
yes, he is for
I'm
the
the appealing man.
acquitted,
My appeal is
Opposite.
against the
he is
acquittal.
for the informant,
Okay, you are for the informant,
Yes.
appeal against acquittal.
but where is the?
Ah,
other side?
Yes.
SD Purkasto, S Chaudhary, R225. There are 4 or 5 accused.
Now what to do?
But
Other side is not here.
the problem is there. Because the private respondent is here, one of the accused, they were the accused in the original case, madam. So I think their presence is necessary.
Very much necessary. SD Prakashta was there earlier. He's here.
Ah,
At 2 p.m. maybe fixed, madam. Because the case, I think, it will not take some more time, madam.
because
If possible, at 2
evidences
PM.
are very little. I mean, a girl was found dead with a
At 2
locket,
p.m., madam.
with a,
In the meantime,
Lock.
courtmaster will show in the,
Now
Well,
was found in. was found-
girl was found dead in the field with a lock of a chain in her hand. And then the witnesses said that the lock belongs to the jacket worn by the accused, one of them. And they had actually taken the daughter from the house of the informant. One boy. Babu was the main accused
Any-
here. He had a relationship with the daughter. And he took out
So,
at night.
it-
and
it
then the
had-
daughter-
That thing was taken. in
That
her
is
hand.
what the only evidence, otherwise.
But then it appears to be quite a serious issue.
Last scene was the only ground on which it was
No,
acquitted
but
because.
what about that? Was it proved that
No,
what was in her
sometimes,
hand
but-
was?
And not proved to that extent. Accused said, some of the witness said that it belonged to his jacket. But then the lock of the chain is difficult to prove. And the trial got acquitted only on the ground that last scene was too long. Last scene at night and the morning body was found.
But
the
then
last
what
scene-
was his alibi?
He would simply said it's false. And there are contradictions. The informant and the other family members said that both of them went out at night for a walk. That they did not say it before the police. So there are some contradictions. Whether at all they went out that night.
What will the matter? What will it- is there? Okay, we see at 2 o'clock. if it's-
problem. If you mention the name of the advocate, kindly be shown in the.
Mayor, please, your lordship, my senior is in another court. May the
Who is the senior?
A Tiwari.
K. Tiwari. Okay, anyway, you guys start, I think. Is there anyone ready? Any councils are ready?
Council.
No.
Yesterday's matter is also fixed today of NJ Das. He is also not there.
NJ Das is,
Supplementary.
MIKS, will appoint someone.
He come, he said yesterday.
He said it will come.
He said, I talked to him.
Maybe because anyway, we'll see it's just 12 minutes. Not 12 minutes, sorry, 10:15 we started.
10,
Ah, okay. So just 27 minutes. everyone. And anyway, I think, madam, you can start.
I can start.
Let As soon as your senior comes, he will join. By the time, hopefully the prosecution has not, has not convinced us.
There are lasting theory, your lordship, and there are leading to discovery as well as extrajudicial confession. I found these three circumstances against the
Now,
accused.
what is it? One is last seen theory.
Yes. Then there is leading to discovery of the dead body.
This discovery of dead body.
Yes.
Discovery of dead body
And your lordship.
on the basis of the disclosure.
Yes, disclosure, the dead body was recovered.
Number 3,
Number 3 is extrajudicial confession. Just now I have gone through while hurriedly. Other side has come, yeah, the previous matter. Oh, it is fixed at 2, right?
do you call Mr. Prakash?
Yes,
No, I think the
Prakash,
other,
last day. Oh,
or others we can start, no
Okay.
point. We have already
Okay.
fixed that too.
Lordship. Lordship, in the case in hand, the FIR is at page 4.
Page 4,
Yes. It has been lost by the mother of the victim, Lordship, grandmother of the victim.
page 4 FIR dated
FIR dated 17/1, my lord.
17/1,
2017,
2017 by mother,
grandmother,
grandmother, grandmother of victim.
yes.
PW number,
PW number 1.
okay.
Incident that the girl went missing on 15/1, my lord. 15/1 girl went missing, dead body was recovered on 17/1. And on that day, the FIR was lodged.
Dead body recovered
Yes, ma'am.
on 17/1.
Yes. May I take your lordship to the FIR, your lordship,
Yes.
at page 4.
Yes.
Humble submission is that Khadija Khatun, the 4-year-old daughter of my youngest son, Muhammad Hussein Ali, had been missing from home since 15/1/2017. After failing to trace her, even after extensive search, suspicion arose in my mind against my daughter-in-law, that is the above-mentioned accused person. On being questioned, her with the help of the public, she replied that she had thrown her into a kacha well located at number 3, Kring Kring, Chadiaghar. Around 7:08 a.m. today, that is on 17/1/17, I, accompanied by public, came to the Norkhuti police outpost and informed verbally about the incident. I, along with police, went to the said kacha well at number 3, Kring Kring, Chadiaghar, and when the accused showed the well, we saw the dead body of the girl floating in the water of the well. The accused confessed that she took Khadija Khatun and killed her by throwing her into the well. I therefore request you to take necessary action after investigating into the
What about
matter.
in 313, what has happened?
Lordship, 313 at page 24. She denied, my lord. Answer to question number 1. I did not confess or state before police about killing of victim Khadija. She deposed falsely against me. Then, all your lordship, no explanation, false, yes, false.
This disclosure was made before whom?
My lord. Yes, I'll take your lordship to the evidence of the IO also.
No,
Lordship is-
disclosure was
Yes.
made before whom?
Disclosure statement has to be made before the IO, and prior to that, she has confessed before the public also that she has killed and thrown the dead body, my lordship. May I first take your lordship to the evidence of PW1? Mallika Khatun,
Page?
page 9.
Yes.
I am the informant of this case. The accused is my daughter-in-law. The incident took place in the month of January last. On the day of the incident, my son Sulman Ali went out to the house for some work. Then a quarrel took place between my daughter-in-law and me. She told me to go out of the house. Then I went to say the matter to public. At that time, my granddaughter Khudeza and accused Fatima were at home. When I came home, I did not see both of them. While I was searching for Khudeza, people said that they saw Khudeza going to the house of Fatima's father with Fatima. I immediately went to the house of Fatima's father, but did not see Fatima and my granddaughter Khudeja there. After making search for 2 days, we could not trace her. I again went to the house of Fatima, and when I asked Fatima about my granddaughter, she had threatened me. Later, Fatima's sister-in-law, wife of her elder brother, informed me that both Fatima and Khudeja went out together, but Fatima returned alone. Taking along the village headman, I again went to the house of Fatima's father. After failing to trace the girl, I informed the Nokoti police outpost on the following day. When police asked Fatima about the girl, she replied that she had killed the girl. Hearing this, I became unconscious. 2 days after the incident, the dead body of the girl was recovered from a well. Police lifted the girl from the well as shown by Fatima. I lodged the Azahar with the PS. I put my thumb impression therein. Then crossed. The girl went missing on Sunday. Police came on Monday evening and examined Fatima. Police again came on Tuesday. As I could not find my granddaughter, I lodged an Azahar with the PS, taking along my co-villagers. Then Hussein doctor wrote the Azahar for me. I did not see the dead body in the well. The Azahar was written as per my version. I did not mention at the time of writing the Azahar that when the accused showed the well, I saw the girl floating in the well. It is not a fact that I did not mention in the Azahar that on the day of the incident, both my younger son Hussein Ali and daughter Khadija had gone missing together. The house of Fatima's father is situated about 2 kilometers away from that of me. On Sunday, I informed my co-villagers, namely Abdul Malik, Saiful Islam, Rahima Khatun, and Abu Nasir Wahed about the incident. They could not trace my granddaughter. The well is situated about half kilometer away from my house. It is a Kacha well. There are 4 families at my campus. There were no one there when Fatima departed. It is not a fact that while the girl was playing, she fell into the well and died. It is not a fact that out of suspicion, I lodged a Azahar against my daughter-in-law. I did not state before police that when I went to inform the villagers, Fatima and Khadija were at home and that Fatima went out with Khadija. I did not state before police the facts that I stated before the examination chief. It is not a fact that doctor did not write the Azahar. Suleiman married another woman after Fatima was imprisoned.
Just a
Then
minute,
PW
just a minute, madam.
My lord,
You see, in her evidence,
my lord,
PW1
my lord.
does not say anything about the appellant having disclosed that she had thrown the baby or the child into a well. The FIR, the contents of the FIR and her evidence,
My lord,
they are not similar. Where does she say in her evidence that the appellant had stated that she had thrown the baby into the well? The child into the well.
But police lifted the girl from the well as shown
That
by
is a
Fatima.
different
That
thing.
is there.
That is a different thing.
Yes.
Only thing is that when police asked Fatima about the girl, she replied that she killed the girl. How did she kill the girl? Where? Nothing is said.
Let us see evidence of other minor. Hurriedly, I have
No,
gone to
no,
the evidence of the court.
because you see,
Yes,
in the FIR,
Yes.
come to the FIR
my
again.
lord. Lordship, it's there.
Yes,
On being questioned, her. with the-
Correct.
Yes,
on being questioned her with the help of public, she replied that she had thrown her into a kacha well located. This statement made by her, it is not there in the evidence.
yes, that is not there,
Yes.
my lord. But FIR is not the encyclopedia, your lordship.
Correct, it's a-
And lordship, there are two parts.
FIR is not the encyclopedia, but
Yes.
the evidence has to contain. that.
Lordship,
So where is the
but your
disclosure?
lordship, even if she admits she has skill, it will be exculpatory part, inculpatory part. Exculpatory part regarding the leading to discovery will be admissible in evidence, not that she has skill will not be admissible in evidence. my
Correct,
lord. Yes.
correct. But where does it show that she had taken them to the well? That the appellant, where does it show in your evidence
My lord,
that the appellant had taken the police
Uh,
or you to the
Lordship,
well.
Spirit, let us go to the evidence of other persons if I could find out something, my lord. PW2 Saiful Islam. And when your lordship, the victim was found going along with the accused person, the reasonable explanation is expected from the accused person when she departed the company of the victim. My lord. It's not there.
Now, why is she living in her father's house? She should have been living with the informant. if you- if you
Evidence says she has taken the victim. She was seen
Madam,
going,
madam,
yes,
madam,
my lord,
one thing at a time.
my lord,
When you look at the evidence of PW1,
my lord.
she says that when I came home, I did not see both of them, her two grandchildren. When I was searching for Khadija, people said they saw Khadija going to the house of Fatima's father with
Yes.
Fatima.
Fatima is the accused person.
I immediately went to the house of Fatima's father, but did not see Fatima and my granddaughter there. After being searched for 2 days, we could not trace her. I again went to the house of Fatima. And when I asked Fatima about my granddaughter, she had threatened me. So. When you read this entire evidence, it appears that Fatima is living with her father, not with the mother-in-law.
But your lordship, they had a fight. There was a quarrel. This Malika and Fatima, they had a quarrel under.
What happened?
Saiful.
Does Fatima have a husband or not?
Lordship,
Living
that is
husband?
there. She remarried. Suleiman married another woman after Fatima was in prison. Remarried was there, but then later on.
That is after. That
After,
is
after,
after. That
after.
is after. That is the thing that is after. her.
Lordship, when I went to inform of it, Fatima and Khadija went home, and then Fatima went out with Khadija. Lordship, let us go to the evidence of PW2, if I could find out something like that. Saiful Islam. Page 12. I know the informant as well as the accused. The incident took place in the month of January last. While I was returning home from Lalmati, I saw Fatima and Khudeja going by the road. This person also saw Fatima and Khudeja, the victim, going by the road. I saw them going towards Haldibari. I saw the girl going on Sunday. On Tuesday, police recovered a dead body of Khudeja from a well. Then in cross, my lord, it is not a fact that I did not state before police that I met Fatima on the road. I did not tell the informant that Fatima was going with Khudeja. It is not a fact that I have deposed falsely that Fatima was going towards Haldibari with Khudeja. Then PW3, Abdul Malik. Very short, Maya, read your lordship. All of the evidence, only 7 witnesses are there. PW3, your lordship. I know the informant and the accused. The incident took place on a Sunday in the month of January last. On that day, while I was walking at turmeric cultivation, I saw Fatima taking along Khudeja. He also saw Fatima, my lord, going towards her father's house. When she returned, Khudeja was not with her. I heard that the dead body of Khudeja was recovered from a well on Tuesday. I do not know as to who had killed Khadija and how. On Sunday, Khadija was going with Fatima. It is not a fact that I did not state before police the facts that I have stated in the court today. It is not a fact that Khadija did not go with Fatima. Then PW4, Abu Nasar Wahid. I know the informant as well as the accused. The incident took place in the year 2017. On the day of incident, the informant lodged a Azahar with Lakuti outpost informing that her granddaughter went missing. The informant also asked me to make a search for her granddaughter. Then the PS also instructed me to make a search. On the following day, the informant again lodged in Azahar, alleging that the accused took the victim girl to the house of her father. On her return, she did not bring the victim with her, but brought her own daughter. When the accuser's questioned, she confessed that she threw the girl into a well. Here, my lord, extrajudicial confession part is there. When the police questioned the accused again, she showed the well where she threw the girl. Then we went near the well. Police also went there. We lifted the dead body of the girl from the well. When the magistrate held inquest, so and so is the signature. I heard the accused person confession. She confessed that she took the girl and threw her into a well. The name of the girl was Pudeza Khatun. The dead body of the girl was recovered 3 days after the incident. I stated before the police that people made a search and 3 days after the incident saw the dead body of Khadija, the missing girl, floating in a well near the accused person's maternal home. I also stated that on being informed the matter to police, the magistrate came from Shankardev Nagar and then the dead body was lifted from the well. It is not a fact that I did not state before police that the informant informed me that the girl was missing. My house is about 1 kilometer away from the house of the informant. I didn't question the accused. It is not a fact that the accused did not confess before the public that she herself threw the girl into the well. Then the evidence of the doctor, my lord. Date is in the opinion of the doctor at page 19. In my opinion, death was due to suffocation, asphyxia as a result of effect of maybe drowning, my lord. This written is going. Exact time of death was not mentioned in my report. Rigor mortis was present. It could be more than 4 hours. If accidentally fall water, it may happen as such. PW6, the IO money. Lordship, may I take your lordship to the evidence of IO at page 20? On 17/1/17, I was working as attached officer at Lamding PS. On that day, one Mallika Khatun lodged an Azahar and Narkoti PP. And after receiving the FR, I see Narkoti PP recorded a Narkoti PP GD entry number 252 dated 17/1/17 and forwarded the FIR to OC Lamding PS to register the same. And accordingly, OC Lamding PS registered the case as Lamding PS case number 14/17 and endorsed me to investigate the same. After receiving the FIR, I along with OC and other staff along with executive magistrate Vijita Deka visited the PO. After arrival at PO at number 3 Kring nearby a small tilla in a small well about 10 feet deep, the dead body of the victim Khadija Khatun, aged about 4 years, was found in floating condition. We recovered the dead body. After recovery of the dead body, the executive magistrate conducted the inquest over the dead body. I did a rough sketch map at the PO. And I examined the witnesses, namely Mallika Khatun, Abdul Malek, Saiful Islam, Rohima Khatun, Rabija Khatun, and Abu Nasir Wahid. I sent the dead body to BPCH for postmortem. Then we came back to Narkoti PP from the PO. On arrival of the PP, we found that local people captured the accused Fatima Khatun and handed over to us. Then I took custody of the accused. I also interrogated the accused Fatima Khatun and forwarded the accused to court for judicial custody. On direction of the OC Lamding PS, I handed over the CD to the then ICSI Jugendranath Deka for further investigation. Is the sketch map as the signature. Then I performed the investigation of this case only after 1 day, that is on 17/1/17 itself. I handed over the CD on OC Lamding PS after arrival of the Narkoti PP. We found that some people brought the accused Fatima Khatun at Narkoti PP, but by whom she was brought at Narkoti PP, I have not mentioned the name of those persons. On 17/1/17, the OC of Lamding PS was all along with us, present with during the period of investigation of the case. I did not record a statement of the OC Lamding PS as witness of this case. Even I did not record the statement of Executive Magistrate Vijita Deka. I forwarded the accused Fatima to the court of SDJM of Sankadev Nagar on 17/1/17 at about 3 p.m. The well in which the dead body was found was a mud well. There was no wall or guard in the well. The said well was made for human use. I did not peruse the content of the inquest. The inquest was prepared at PO and the same was handed over to me at the PO. PW2 Saiful Islam did not state before me that he saw Fatima Khatun was going through road. It is not a fact that witness Abu Nasir Wahid did not state before me that informant Mallika Khatun did not tell me about the missing of the victim girl. The date of occurrence was 15/1/17. Then your lordship PW7 is the lordship, another IO, my lord. On 25/2/2017, I was working as IC Norkoti PP under Lamding PS. On that day, I was handed over the city to Lamding
What is
PS. case
PP?
number-
What is Nakuti PP?
Police post. Petrol post. I was handed over the CD Lamding PS case number so and so, Munindra Chomonda. The previous investigating officer, SS Deb and JN Deka, have almost completed the investigation of the case. And on their transfer, I was endorsed to complete the investigation. After receiving the CD, I collected the PM report from BP Civil Hospital. As the investigation was completed, I filed a charge sheet on so and so against the accused under 302. Before filing the charge sheet, I have gone through the CD thoroughly. I have now recorded a statement of Azahar written Abdul Malik. In the inquest report that is exhibit 1, the case number, GD entry number is not mentioned. The magistrate by whom the inquest was prepared, his or her name was not mentioned in the inquest. At the time of filing of the CS, I have not gone through the inquest report. Later on, it is found that Executive Minister Bijita Deka had prepared the inquest report. I have not recorded a statement of Executive Magistrate, so and so. I have not examined the autopsy surgeon who had performed the autopsy in connection with this case. Nothing much is discernible. Then the evidence of the magistrate, my lord, Eastern Commissioner who conducted inquest at page 23. On 17/1/17, I was working as Eastern Commissioner DC office Hojai. On that day, I conducted the inquest over the dead body of a female child, namely Khadija Khatun. Is it about 4 years old, being identified by Malika Khatun? Position of the dead body was lying upside down inside the well. Blood seen in the face, lips were white and stomach was swollen. Some of the witnesses told me that the victim was killed by her stepmother Fatima Khatun and directly thrown in the well. I prepared the inquest report in presence of witnesses. Then cross. No any GD entry or any PS case numbers written in the inquest report prepared by me. The dead body was found from the village number 3, Kring number so and so. The dead body was found on 17/1 and the time is 9:30. Lordship, I don't think it's important, your lordship. Lordship, may I see the records, my lord? Because from the evidence of the IO, lordship, dead body was already recovered before she was taken into custody. So,
It's
lordship,
recovered by the public.
public, my lord.
Disclosure not made to police.
May I see the records?
Yes.
Record to which? Lordship, 17/1/17 and 7:30, Ajara was lost. Lordship, may kindly note, 17/1/17,
Yes, what time?
7:30,
7:30 AM.
yes. And there was GD entry number 252 dated 17/1/17. May I read the Assamese? Etia Mosamman Maleka Khatun Sami Mito Umed Ali. Mito Umed Ali so and so or Thana Lamding Jila Huzai Okham Sukit Hajir Ekhon Likhito Ejar di জনাই যে যোৱা ইংৰাজী 15 তাৰিখৰ পৰা তেওঁৰ সৰু ল'ৰা মছম্মদ হুছেইন আলী 4 বছৰীয়া ছোৱালী মছম্মদ খাদিজা খাতুন ঘৰৰ পৰা নিৰুদ্দেশ হৈ আছিল। বহু ঠাই বিচাৰি নাপাই তেওঁ বোৱাৰী মছম্মদ ফাতেমা খাতুন স্বামী সুলমান আলী so and so ঘৰ থানা লামডিঙৰ সন্দেহ হোৱা ৰাইজৰ সহযোগত সোধপোছ কৰা তেওঁ 3 নম্বৰ খিং ঘৰৰ এটা কেঁচা খোৱা তেওঁ কণমানি শিশুটি পেলাই দিছে। তেতিয়া এজাৰকাৰণী ৰাইজৰ সহযোগত আহি 17/1/17 তাৰিখে 8 বজাত 9 কোটি আৰক্ষী চকীত আহি তেওঁ মৌখিকে ঘটনাৰ কথা প্ৰকাশ কৰে লগতে পুলিচৰ লগত গৈ উক্ত কোৱাটোৰ এই 3 নম্বৰ so and so 14 ঘৰীয়া বুলি কোৱাটো মোহাম্মদ মোছাম্মদ ফাতেমা খাতুনে পুলিচৰ সহযোগত লৈ উক্ত মতে দেখাই দিয়ে। উক্ত মহিলাগৰাকীয়ে মোছাম্মদ খাদিজা খাতুন জীৱিত অৱস্থাত নি কুৱাত পেলাই হত্যা কৰা বুলি স্বীকাৰ কৰে মতে Then 7:35 AM is a note of the IO. I now, along with available staff accompanying with the OC Lamding PS, left the Norkuti PP. Then 8:10 AM, I now accompanied with the OC Lamding staff arrived at Norkuti PS. PP. I have discussed about the PO location with the PP staff and took stock of the situation. Then 8:20 AM, I now along with the staff accompanied with the OC Lamding PS left for the PO. Then 8:45 AM, I now along with the staff accompanied with the Lamding PS so and so. The PO is a borewell about 10 feet deep on an open area and at the foot of a small tilla, one side covered by bamboos. I have drawn up one rough sketch map of the PO on a separate sheet, which is enclosed herewith. I've also examined the below noted witnesses and recorded their statements on separate sheet, which was enclosed herewith. Then, my lord. At 9:15 AM, my lord. Now, Executive Magistrate Simoti Bijita Teka arrived at PO. Executive Magistrate hold inquest over the dead body. Khadija Khatun so and so after it lifted out of the well. After the inquest was done, dead body was challan forwarding report, etc.
So when
Yeah.
was it, when was the dead body taken out from the well?
9:15. 9:15 AM by the Executive Magistrate. 9:15 AM inquest was done. So prior to that, it was recovered. Lordship. Lordship, at 1 PM on the same day, I now along with the staff and accompanied with the OC Lamding PS arrived at a Norkuti PP note. On arrival at Norkuti PP found that local people captured the accused Fatima Khatun and handed over Norkuti PP. I have taken, well, prior to that it was recovered. I have taken the accused in a
So
custody as
recovered by the police, recovered by the public.
public, but it's not lordship because they have already took the recorded the evidence of the witnesses. The note of the IO says, I have also examined the below noted witnesses and recorded their statements or separate sheet which was enclosed herewith. Then thereafter, executive magistrate comes and lordship inquest was done. But in between, when she was taken into custody, it says that on being handed over by the public, she was taken into custody at 1 PM.
So, but then he says that we recovered the dead body. PW6 also says we recovered the dead.
Yes,
From where?
yes, by the time the police arrived, my lord, the dead body was recovered.
PW6 is the investigating officer.
Yes,
In his evidence,
my lord.
he says that we recovered the dead body.
Yes,
But actually, he was not there. So where's the question of we?
lordship. That portion, my lord, I did not find it. my lord.
Huh?
That-
We recovered is at 1, 2, 3, 4, 5, 6, 7, 8, 9. Ninth
Lord,
line,
my lord.
page 20.
Lordship, 8:45 AM on 17/1. I now along with the staff accompanied with the OC Lamding arrived at PO. The PO is a borewell about 10 feet deep so and so.
I was doing an amicus matter.
Accused was captured at 1 PM. I now along with the staff and the captured accused accompanied the OC Lamding place left Norkuti for Lamding and closed the city so and so.
Accused was captured at 1 PM, then how could the villagers have Recovered the body on the basis of the disclosure made.
CD doesn't say anything. May I see if I find out something?
This is basically what has happened. We want to clear the parenting hospital division. And the villagers have taken over. Yes,
Lost
There
him.
there was a, my lord, there was a defective investigation in this case. If I take your lordship to the
let it,
evidence of the IOs, my lord.
Yes.
yes,
If I take the evidence of the IOs, my lord would kindly turn to page page 20, my lord, page
yes,
20.
yes,
My lord would just skip 6 lines from above, my lord.
yes,
After arrival,
yes,
after arrival at PO at number 3 Kiring, nearby a small tila in a small whale, about 10 feet deep, the dead body of the victim, Khadija Khatun, aged about 4 years, was found in floating condition. Now, my lord would note floating condition. We recovered the dead body. After recovery of the dead body, the executive magistrate conducted the inquest over the dead body. I do this rough sketch match. I examined the witness, namely Malika Khatun, Abdul Malik. This is the PW, my lord, 3, Saiful Islam, PW 2,
just a minute. Malika Khatun is PW,
1,
then Abdul Malik,
Abdul Malik, PW 3, my lord,
Saiful Islam,
PW 2, my lord,
Romina,
not examined, my lord,
Huh?
not examined,
Rohima Khatun not examined,
not examined, my lord.
but he says that he examined.
No. Rahima not.
No, IO examined.
IOS examined. IOS examined, but these were
But he's not
not
examined.
brought as witness in the court, my lord.
Then Babija Khatun,
Not brought, my lord, but Abdul Nazir Wazir was examined, my lord.
PW.
He was PW 4, my lord.
Ah,
Then, my lord, I sent the dead body to BPCH for postmortem examination. Then we came back to the Nakoti PP from the PO. On arrival at PP, we found that local people has captured Fatima, meaning thereby that from Fatima did not show the well, neither she was present there, my lord. Because from the PW1 statement also I'll show that, my lord, and handed over to us. Then I took the custody of the accused. I also interrogated the accused Fatima Khatun and forwarded the accused to the for judicial custody. Now in the cross part, my lord would find I performed the investigation of this case only for 1 day. And on 17/7 itself, I handed over the CD to the OC Lamding PS only for a day. We
Yes.
found that some people brought the accused Fatima at Nakoti police post. But by whom she was
police
brought
post
at,
a petrol post, but
yes, petrol post, my lord, correct. But by whom she was brought at Nakoti police post, I have not mentioned the name of those persons. On 17/7, the OC Lamding PS was all along with us present during the period of the investigation. I did not record the statement of the OC as witness of this case. Even I did not record the statement of the executive magistrate who conducted the inquest, my lord. Vijita Deka is the learned executive magistrate, my lord, who conducted the. I forwarded the accused.
okay,
Fatima-
we'll come back after 2
My-
minutes.
my- my- देखो हैंडनोट तो कैसे करना है हैंडनोट भी फाइल भी मैं वीडियो से टाइप करता हूँ देखना वीडियो से इधर सुनना तो जजमेंट हम जेरॉक्स करके लेंगे ओ वेरी गुड इसको क्या वो मेरा नोट देखना देखना वीडियो से टाइप करना मैं देखो नीचे हैंडनोट पे लिखना मत रहेगा कुछ नहीं है वो सीनियर अराउंड मूवी तो है ना है ना
Yes,
page 21 my lord
21, yes.
Well, I was reading the cross part, my lord.
Yes.
The second line says, I did not record the statement of the OC Lambding PS as witness of this case. I did not record the statement of the executive magistrate Bijita Deka. I forwarded the accused Fatima to the court of SDGM on so and so. The well in which the dead body was found was a mud well. There was no wall or guard in the well. This is important, my lord. The said well was made for human use. I did not pursue the content of the inquest. Now this, he says he did not pursue the contents of the inquest. The inquest was prepared at the PO, place of occurrence, and the same was handed over to me by me at the PO. PW2 Saiful Islam did not state before me that he saw Fatima Khatun was going through the road. Now this PW, my lord, 2 has not stated that part, my lord. It is a fact that the witness Abu Nazir Wahid did not state before me that the informant Malika Khatun did not tell me about the missing of the victim. However, my lord, he is a VDP secretary, my lord, but in chief, he has stated that Malika Khatun came to me and said that my granddaughter is missing. So I made a search. That is there. My lord, I'll just place that part also. Now, my lord, page 22. This second,
No, just a minute. The inquest was prepared the same as handed to me. PW2 did not state before me that he saw Fatima Khatun. What does PW2 state? Say,
now, my lord, PW2 is Saiful Islam, my lord.
Where?
Cross part page 13. Cross part page 13.
yes,
It is not a fact that I did not state before police that I met Fatima on the road. I did not tell the informant that Fatima was going with Khatima. I did not tell the informant that Fatima was going with Khudeja. Means the granddaughter, this accused was not going with Khudwa. He did not tell that, my lord. On the strength of this 2 and 3, my lord, the conviction is there, my lord. Now page 22.
no, just a minute. Who is 3?
3 is, my lord, Abdul Malik.
Ah,
Now, Abdul Malik in his chief says that I know the informant and the accused. The incident took place on a Sunday in the month of January last. On that day, while I was working at Thermic Cultivation, I saw Fatima taking along Khudeja proceeding towards her father's house. When she returned, Khudeja was not with her.
ah.
I heard that the dead body of Khudeja was recovered from a well on Tuesday. I heard. I do not know as to who had killed Khadija and how. On Sunday, Khadija was going with Fatima. It is not a fact that I did not state before the police that the fact that I have stated in the court today.
Sunday, what is the date? Sunday is what date?
15, my lord. 15/1/17.
And body was recovered on?
17. And if the, my lord, the cross of the doctor, my lord, who conducted the autopsy or postmortem, my lord, he says that the time between death is 4 hours only. My lord, I'll just take your lordship to the evidence of the, my lord, page
Just a minute.
19.
Who is this Abu Nasir Wahid?
He is the VDP secretary of the town,
PW4.
PW4, my lord.
But in fact, he has stated before the IO.
Huh? Just a minute. Huh?
But he has stated before the IO.
Who was stated before the
Abdul Nasir.
stated what?
That he saw the victim along with the accused person.
No, my lord, but the evidence says something different. I'll read out the
So your
evidence.
lordship, there's a
PW4, my
necessity
lord.
to see the case there is sometimes, my lord, to see the records. Because most of the times we have found IO before the court, whatever is the stated before the, when the witnesses stated before him, whatever is recorded under 161, the IO says it was not stated before him. In the court, he gives another
Version.
state, yes, which is the horse record.
So then what happened? What does that imply?
Then your lordship may kindly have a look
No,
whether
no.
it
So
matches, because
if there is a discrepancy between the CD and the evidence given by the IO,
my lord,
what does that imply?
because your lordship,
So,
the witness, according to the IO, these witnesses has not stated before him. But in fact, he has stated before the IO. And in the substantive evidence also, the witnesses is deposed that he has stated before the IO. And his statement is
no,
negative.
madam, there is one thing, I'm just asking. If there is a discrepancy
Yes,
between the CD,
yes,
which has been made by the
my
IO,
lord,
and his evidence before the trial court,
my lord.
We are supposed to believe which one, the CD or the evidence?
Evidence,
Oh,
my lord,
we are
but
supposed to
for
believe
the
that.
ends of justice, your lordship may still have a look at the, for the ends of
And
justice,
if we find for
yes,
the ends of justice
my lord,
that there is a discrepancy, a contradiction,
my lord.
then what are we supposed to do? Supposed to accept the CD version or the evidence version?
Evidence person, your lordship will rely upon. But when there is doubt which arises in the minds of this honorable court, your lordship may still have a look because the procedures
so-
are not followed in the trial.
So should we say that the IO is an unreliable witness?
Most of the, although our witness, my lord, for the lordship, because
If
of
there
the,
is a contradiction, do we say that he's a reliable witness or he's an unreliable witness?
our witness, we cannot say he is unreliable witness, but we have to see the, my lord, the, sometimes
but
for
then-
ends of justice, my lord,
No, for the end of justice, okay. We will try to find out the truth.
my lord.
But at the end of the day, what does it mean? It means that he's unreliable.
Sometimes for the reasons unknown, they depose falsely before the court, my lord. Whatever is on record, they do not place it there because as per rule, they have to show it to the witness concerned. Have you stated before me? And it has to be marked, my lord. But these procedures are not followed, my lord, properly.
But then the IO is not the prosecutor in the court. It is the prosecutor is a different person.
And if, my lord, I'll read out the when the OC statement, my lord.
Or you see, then it is the duty of the prosecutor to maybe confront the IO.
Yes, yes.
Then how can you blame the IO for that?
IO as well as the prosecutor
Both
concerned.
of them.
It happens, your lordship is aware of it, my lord. In 90% cases we found. The witness is stated before him and he comes before the court and says it was not stated before him.
Okay, even if it was stated, let us see again PW4's evidence.
My lord, can you see now, my lord? I know the informant as well as the accused. The incident took place in the year 2017. On that day of the incident, the informant lodged an HR with Nakoti outpost informing that her granddaughter went missing. The informant also asked me to make a search, Now this witness says that for her granddaughter. Then the PS also instructed me to make a search.
PS means
The police station, the police official, my lord.
police station, but it is Nakoti outpost anyway.
Yes.
Uh,
On the following day, the informant again lodged an HR. alleging
Second
that-
AJR. A second AJR.
Second HR. That the accused took the victim to the house of her father. On her return, she did not bring the victim with her, but brought her own daughter. When the accused was questioned, she confessed that she threw the girl into well. Now this confession, my lord, I'll show from the cross-examination.
Just a minute.
When the
therefore,
police
on
questioned
her
the-
return, she did not bring the victim with her, but brought her own daughter. On her return, she did not bring the victim with her, but brought her own daughter.
Own daughter.
What does that mean?
One of the granddaughters who is missing, my lord, is the stepdaughter from his
Okay.
first wife.
Okay.
From the first wife, that daughter was there, man. Now, my lord, I'll show, my lord. Yeah. When the accused was questioned, she confessed that she threw the girl into a well. When the police questioned the accused, again she showed the well where she was thrown. Whereas the IO says that she was directly brought to the police post. She was never there at the time when the girl was recovered, neither she was there in the well, this Fatima. So this statement entirely goes. Then I'll say, then we went near the
Just a
well.
minute. When the accused was questioned,
The accused,
she
Again,
confessed
she
that
showed
she
the
threw
well.
the girl into. Questioned by whom?
Maharaj, this is the chief which the VDP secretary gave in the court. This is the chief.
When the police questioned the accused, she showed the well, but this is also wrong.
She
Nothing-
was directly there in the police post.
One extrajudicial confession made before the public. And lordship, public has already she was detained, victim was, accused was detained by the public. Later on, police arrived, my lord. So that part will not go, that lordship, the leading to discovery, that will not be admissible. But your lordship, the extrajudicial confession which is made before the public and the last instant theory will still remain.
Last scene theory is
So
that
which kind of
but-
evidence still,
but
your lordship?
15th was the last scene.
Last scene.
and recovery of body was 17.
17.
But there's a lordship duty cast on her also on what time she has departed the uh, company of the victim, my lord. There is no explanation.
Only one line I'll show from the cross, my lord. Only one.
Only
Just
two
a
Down below
circumstances
that.
which
Last three
against
lines,
him.
my lord. Last 3 lines. I did not question
Just
the
a
accused.
minute, then we went near the well. Police also went there.
Went there. We lifted the dead body of the girl from the well.
So that implies that she had also made the disclosure before the police,
Later on, my lord.
not later on. As per the evidence, then we went near the well. Please come to page 17.
My lord. When near the well, police also went there.
Then we lifted
Lifted
the dead
of the
body
girl
from the
from
well. So that means the disclosure was made by Fatima to the police prior to the dead body being lifted from the well.
Recovered.
But, yes, then it would be admissible, but I did not find it in the record. I may be wrong. Your
That's
Lordship.
why-
Kindly have a look,
Huh?
please. Because arrest on 17/1 at 1 PM, 1 PM taken into custody. Prior to that, there was
And-
an inquest.
So that is what, so what he's trying to say is that the evidence of PW4 is suspect.
Yes.
He's not a reliable witness. That's what he's trying to say.
My contention is that that part will not be there, that leading to discovery that's shown by the accused part will not be admissible. Because by that time, which goes in his favor, my lord, because the public has already detained her. And she was taken to I may be wrong, my lord, in submitting, but she was taken to custody later on, after the dead body was recovered. So that part will not be
No, no,
admissible.
custody might be taken, forget custody, let's forget custody. When we read this evidence
My lord,
at page 17, it says, when the police questioned the accused again, she showed the well where she threw the girl.
my lord,
Then we went near the well. Police also went there.
yes.
We lifted the dead body of the girl from the well.
Right.
So what does that mean? It means that the accused had told the police prior to taking out the body from the well that the girl was in the well. So the public went, the police went, and then they all lifted the body.
Lordship.
Which is
on what
absent in the
basis-
evidence, my lord.
On what basis you stated that, but I don't know, because record doesn't say so, my lord, I may be
Correct,
wrong.
but then that is why I'm asking the PP. What should we believe? The evidence recorded or something else?
But a disclosure statement,
There is no
that the
disclosure.
accused person has to.
Where is
be-
the disclosure
No
statement?
There's
no
nothing.
disclosure statement.
Lordship, so it goes in his favor, I'm submitting, that there two circumstances remain, that is the extrajudicial confession as well as last in theory. There's two circumstances which goes against him, the disclosure and the leading to discovery will not be,
Ah,
which goes in his favor.
so what goes against him according to you extrajudicial?
Extrajudicial as
Which
well
one?
last in theory.
Which one? Which extrajudicial confession made to whom?
Extrajudicial,
My lord, if hundreds of people have gathered me, I'll definitely say I killed her. In order to.
Lordship
I-
PW 4,
PW4.
yes.
But PW4, my lord, if the cross part is taken, my lord. Kindly see cross
When the
part, page
accused is
17, last 3
questioned, she
lines.
confessed that she threw the girl into a well.
Ah, when the accused was questioned, she confessed that she threw the girl into a well.
That is,
Now.
My lord, cross part, last 3 lines. I did not question the accused. Kindly see cross part, last 3 lines. I did not question. I did not question the accused.
and your lordship, it is not a fact that the accused did not confess before
From
the
the
public that she has
bottom, my lord,
threw the
3
girl
lines
into
above.
well.
I did not question the accused. Where is the extrajudicial confession, my lord?
You see, it says here,
My lord.
when the girl was, you see, can we take a part of the evidence only and leave out some parts of the evidence?
No, it has to be taken as a whole, my.
That has to be there. Now, if it has to be taken as a whole, let us read the evidence as a whole.
My lord,
When the accused was questioned, she confessed that she threw the girl into a well.
my lord.
Okay, now
Yes.
supposing we accept this.
Yes,
When the police questioned the accused again, she showed the well where she threw the girl.
my lord.
Then we went near the well. Police also went there. We lifted the dead body of the girl from the well. So everyone, including the police, heard the accused saying that she had thrown the child into the well. Thereafter, they all went to the well and lifted the body from the well. But the evidence of the police is not to that effect. It is completely at variance with this.
Right.
That
It is regarding the discovery part, my lord, discovery and recovery of the dead body.
no, even
But regarding the other part, that she has confessed before the public.
but then what about confess before the police? If you're
Confession before the police is not admissible under the
no,
law.
no, but then this is the evidence. When the police questioned the accused again, she showed the well where she threw the girl.
That would be admissible regarding the recovery part. But I have gone through the records. It was the accused has to be taken into custody and he should lead the police to recover the dead body
But to whom was the extrajudicial confession made?
before the public.
Which public? Which person in particular?
Lordship,
Now, my lord, the other IO based
this PW4 address, I did not find it. Maybe PW3 also, my lord. Apart from PW4, who states, who has deposed in
He
cross-examination
says,
before the
for
public.
him it's hearsay. He did not question. He says that when the accused was questioned, she confessed that she threw the girl into a well.
My lord.
Okay. Now, he says that I heard the accused person's confession. But he did not question the accused. Okay, now let us continue with him. Let us hear. it.
My lord.
Yes. Yes, you were saying?
now, my lord, page 22. I'll take the lordship to the
No, you said you were saying something about PW number 4 cross-examination. What?
yes, my lord. PW4 page 17, my lord. Now cross examination, my lord. The dead body of the girl was recovered 3 days after the incident. I stated before police that people made a search and 3 days after the incident saw the dead body of Khadija, the missing girl, floating in a well near the accused person's maternal home. I also stated on being informed the matter to police magistrate came from Sankardev and then the dead body was lifted from the well. It is not a fact that I did not state before the police that informant informed me that the girl was missing. My house is about 1 kilometer away from the house of the informant. Now, my lord, the most important part, I did not question the accused.
But what about this aspect that he says that he heard the accused person's confession?
He heard. Now, that is why I'm taking to the IO statement, my lord. Both the IOs, my lord. They did not even interrogate prior to her arrest, my lord. This is what I'm trying to place before this court, my lord.
Yes, sir.
The first one, my lord, I read, my lord, page 20. This IO
Page
has not
20.
stated.
Ah.
In the cross part, this first IO, my lord, the IO who did only for 1 day, my lord, the cross part. I performed the investigation of this case only for 1 day. Itself, I handed over the citizen. We found that some people brought the accused Fatima at Nakoti police post, petrol post.
Ah.
But by whom she was brought at Nakoti Pier, I have not mentioned the name of those persons. On 17/7, the OC Lamding PS was all along with us present during the period of investigation of this case. I did not record any statement of the OC Lamding PS. Even I did not record the statement of Executive Magistrate Bichita Deka. I forwarded the accused Fatima to the court. The well in which the dead body was found was a mud well. There was no wall or guard in the well. The said well was made for human use. I did not pursue the contents of the inquest. The inquest was prepared at the PO and the same was handed over to me at PO. PW2 Sheffield did not state before me that he saw Fatima was going through the road. It is not a fact that Abu Nazir,
It is
Why
a
he did
fact.
not
It
state
is-
before
it
me.
is a fact.
yes, it is a fact. Witness Abu Nasir did not state before me that informant Malika Khatun did not tell me about the missing of the girl. Now, where is the part that he says on arrival? Now, in the chief part, my lord, line number 4, page 20, my lord.
Okay.
On arrival at the petrol post, we found that local people
Rashid, I may be stand
captured the
corrected.
accused Fatima
Just a minute.
and hand over to us. Ek minute. Then I took the custody of the accused. I
Just a
also
minute,
interrogated
where are you reading page
in the
20?
chief part, my lord.
Chief part?
Chief part, line about, my lord, 1, 2, 3, 4, 5, 6, 7, 8. My lord, 8 lines above,
Ah.
from the bottom.
Ah.
On arrival at petrol post, my lord, finds that
No.
1, 2, 3, 4, 5, 6.
Ah,
My lord, got it?
1, 2, 3, 4, 5, 6.
From
Sir.
the below, my lord.
From below.
From below
One,
of
two,
the, my lord,
three,
chief, my lord,
four,
below
five,
the,
6, 7. Huh?
from below the chief, my lord, chief part, my lord.
Ah.
Chief, from the chief part, 8 line above, my lord, on
Ah.
the arrival.
1, 2, 3. On arrival. Huh?
Yes, my lord. On arrival at petrol post, we found that local people captured the accused Fatima Khatun and handed over her to us. Then I took custody of the accused. I also interrogated the accused Fatima and forwarded the accused to the court. So, my lord, in the police station, she was interrogated, not prior to that.
Lordship, I may be stand corrected because I said she was, by the time the public recovered the dead body. There's a note of the IO 7:30 on 17/1/17. May I read it slowly? It's in Assamese, my lord. Wherein it has been stated, my lord. Etia Mosamman Mollika Khatunor Sami Mitode Umed Ali Hang Tinnong Kring Kring Soidhogor Thana Lamding Jila Hujai চকীৰ হাজিৰা এখন লিখিত এজাহাৰ দি জনাই যে যোৱা ইংৰাজী 15 তাৰিখৰ পৰা তেওঁ সৰু ল'ৰা মহম্মদ হুছেইন আলীৰ 4 বছৰীয়া ছোৱালী মছম্মদ খাদিজা খাতুন ঘৰৰ পৰা নিৰুদ্দেশ হৈ আছিল। বহু ঠাই বিচাৰি নেপাই তেওঁ বোৱাৰী মছম্মদ ফাতেমা খাতুন স্বামী মছম্মদ চলেমান আলী আৰু খাং 3 নম্বৰ খ্ৰিং 14 থানা লামডিঙৰ ওপৰত সন্দেহ হোৱাত ৰাইজৰ সহযোগত ফুটফুচ কৰাত তেওঁ 3 নম্বৰ খ্ৰিং 14 ঘৰৰ এটা কেঁচা কুঁৱা তেওঁ কণমানি শিশুটি পেলাই দিছে। এতিয়া এজাহাৰকাৰিনী ৰাইজৰ সহযোগত আজি ইংৰাজী 17 তাৰিখে 7-8 মান বজাত নখুটি আৰক্ষী চকীত আহি তেওঁ মৌখিকে ঘটনাৰ কথা প্ৰকাশ কৰে। লগতে পুলিচক লগত লৈ উক্ত কোৱাত ঠাই 3 নম্বৰ খ্ৰিং 14 ঘৰীয়া বুলি কোৱাত উক্ত মছম্মদ ফাতেমা খাতুনক পুলিচৰ সহযোগত লৈ so accused us with the police উক্ত মতে দেখাই দিয়ে কেঁচা কুঁৱাটোৰ পানী ছোৱালীজনীয়ে মৃতদেহ উপঙি থকা দেখা পায় 7:30 as shown by the accused. The accused is accompanied, police accompanied the accused person. Accused is there with the police person.
Where?
And she showed the place where the dead body.
Look, madam, unless you translate what you just read, I've got no
Lordship,
idea what
I
is
have
talking.
translated, my lord. পুলিচক উক্ত কোৱাটোৰ মই 3 নম্বৰ সয়েন্স ঘৰীয়া বুলি কোৱাত উক্ত Said Mosammad Khatun with the পুলিচৰ সহযোগত with the help of police উক্ত সয়েন্স মতে দেখাই দিয়ে shown by the accused person and in that well the girl was found floating. that the body was found.
What is that? Whose statement is that?
It's the note of the IO at 7:30 PM. Even after the FIR was
I have
lost.
read the statement of the IO, my lord, the chief party says that after he,
But then the evidence of the IO is silent on that aspect. Then what to do? Do we say that, no, we'll have to base our findings on the basis of the CD entry only?
Lordship has to assess it
Uh-huh.
as a whole, your lordship.
So you've got to make up your mind whether we should decide cases on the basis of the CD
Your
or on the
lordship
basis of
cannot.
evidence.
But when your lordship, there's a doubt arises because the evidence of PO, that sometimes necessity to go to the CD also, it's very lordship dangerous to rely on the CD, your lordship.
Yeah.
But regarding only the discovery part, your lordship may rely on, but there is no disclosure statement also of the accused person. But on the record, it says by the evidence of the, not in the evidence, it's a record says the accused led the police for discovery.
But then that is the,
So I leave it to your lordship, but record says something else, the IO says something else before the court. Your lordship signs are also binding because your lordship cannot rely on the CD and but to rely on the substantive evidence.
where does that lead us?
So if that statement goes, the other two circumstances still remain, I respectfully submitting.
Your case is that the last seen theory and extrajudicial confession still
part,
remain.
If it is enough to convict, madam, I leave it to your lordship.
Last seen theory is of 2 days back.
Yes. But the 2-3 witnesses, they have deposed before the court, they have seen the accused person with the company of the deceased. And when she parted the company of the deceased, there would have been reasonable explanation from the side of the
My lord,
accused
case
person that
90
is missing.
the evidence of the doctor who conducted
Doctor.
postmortem, my lord. My lord, we only see the cross-examination part.
Doctor
Exact
says
time of the
before
death was
3.
not mentioned in my report. Regus mortis was present. It could be more than 4 hours.
It could be more than 4 hours, mean it
Then
could be
maybe-
more than 28 days or so, 1 month or so.
So it cannot be
There
presumed that.
there is no
Drowning part
maximum
was-
limit.
And
given.
Riker lordship 3
But
hours.
my lord,
Riker
rigorous
doesn't
mortis
develop.
present
Huh?
was the stiffness in the body was there. That is why he says so. Thereafter he has said,
Riker
rigorous
doesn't
mortis was
develop in 3
present.
hours,
It
your
could be more
lordship.
than 4 hours on that day.
So it could be more than 4 hours.
4 hours. Sheer
Eh,
term.
But he's not given an outer limit.
My lord, that is why my lord, the body becomes soft, my lord.
Huh?
He once lot of water because the other part, my lord, I'll show.
Sorry. Have you seen a body that has been in the water for a week?
Yes, my lord.
Have you seen? It becomes bloated. It
Bloated,
becomes
yes,
pumped
it
up.
becomes
Ah,
like this.
Where is the question of softness? It becomes bloated
It's okay.
fully. The stomach, everything, the whole body becomes
Yes,
bloated.
your lordship is correct. And the incident has taken place in the January, it's a winter timing. Riger so doesn't develop so quickly in 3 hours, it doesn't develop, your lordship. I understand my prosecution's case is weak, your lordship, but these 2 circumstances which go against him.
Anything else? Yes, let's continue.
Now, my lord, page 22, my lord, the other evidence of the IO, my lord. The OC who filed the charge sheet, my lord. Page 22,
Yes.
my lord, may I read the chief, my lord. On 25/2/20, I was working as the IC at Narcotic Patrol Post under Lamding PS. On that day, I was handed over the CD of so and so. The previous investigation officer SS Dev and JN Deka have almost completed the investigation of the case. And on their transfer, I was endorsed to complete the investigation. After receiving the case diary, I collected the PM report from BP Civil Hospital. As the investigation was complete, I filed the charge sheet number so and so, so and so. Then my lord, cross part. Before filing the charge sheet, I have gone through the CD thoroughly. I have not recorded the statement of the HR writer Mohammed Abdul Malik. In the inquest report, exhibit 1, the case number GD entry is not mentioned. The magistrate by whom the inquest was prepared, his or her name was not mentioned. In the inquest report, at the time of filing of CS, I have gone through the inquest report. Later on, it is found that Executive Magistrate Vijita Deka had prepared the inquest report. I have not recorded any statement of the Executive Magistrate Vijita Deka. I am not the medical expert. I have not examined the autopsy surgeon who had performed the autopsy in connection with this case. So, my lord, basically both the IOs, my lord, have not interrogated or conducted the, my lord, investigation in a proper manner, which they were duty bound to do so, my lord, in this case, my lord. Because, my lord, even at some point, my lord, being an amicus, my lord, what I'll submit before this honorable court is that the evidence of the IO who conducted the investigation, my lord, not proper, that prior to she was caught, she led the people to the well. There they found, thereafter they informed us, they took the lady to the police stations. My lord, those parts are completely missing. From the evidence, what comes out is that the lady was caught by certain other people's, my lord. She was directly brought to the police station. In the meantime, some went to the well, my lord, they could recover. Thereafter, they called the police. Police only recovered. When police sent the body to the postmortem for conducting postmortem, then when the police came to the police station, my lord, they found the accused being caught by certain persons, my lord, and she was handed over. Meaning thereby that the extrajudicial confession, if any, was under threat, which the Supreme Court, my lord, have brought certain decisions, my lord, which the Supreme Court says that if in fear or inducement, somebody has given a statement that would never be taken as a confession, my lord. Now, my lord, the PW8, last witness, my lord, Vijita Deka, my lord, the executive magistrate who conducted the, my lord, inquest, my lord. On 17/1/17, I was working at Assistant Commissioner, DC office. On that day, I conducted the inquest over the dead body of a female child, namely Khadija Khatun, aged about 4 years, on being identified by the Malika Khatun. Position of the dead body was lying upside down in the well. Now, my lord, the person who conducted the inquest, he says upside down. He did not say it was floating.
So he can be floating upside down. What does that? How does it matter? He can be floating on his back, can be floating on his stomach, can be floating upside down, can be floating with his legs down. How does it matter? That doesn't mean that when you float, you're going to float in a certain manner. How are you supposed to float? On your back only, or can't you float on your stomach?
My lord, I can.
Then
My lord, but
can't you float with your legs beneath the water and your head above the water?
Butterfly stroke and.
But-
No, no,
generally-
floating
Yes.
is different ways of floating.
Yes.
yes, my lord, different ways of
I-
floating.
Do
That
you,
is-
do
that is
you
correct.
swim? Do you
Yes,
swim?
I swim, my lord.
Then can you float on your stomach? You can't. You can float only on your back.
Yes, my lord.
What kind of a swimmer are you then?
No, my lord, because freestyle, if I'm doing freestyle, my lord, then I.
Freestyle is not floating. Freestyle is you're
Yes,
swimming.
But floating is something, my lord, we only take breath through yoga system and we are floating, my lord.
No.
With the,
You see, floating,
the water, my
floating doesn't mean that you have to breathe. You can be floating for 2 seconds. You can be
Yes, ma'am.
floating for 5 seconds,
ma'am.
10 seconds, 1 minute, 2 minutes. If you float on your back, you float for a long time. If
Very
you
long
float
time.
on your stomach,
Yes.
you can put your head sideways and still, and if you're in the Red Sea or in the, or in the Dead Sea, you can float for hours and hours.
4 hours and hours.
Okay. There's nothing that to be able to float, you have got to float in a certain manner. There's nothing like that.
Now-
Upside down does not give you any advantage. Yes. So
Because otherwise, the, my lord, the well which has come in the evidence is the muddy well, my lord.
So?
So muddy well, my lord, it might be the case that, my lord, the body is stuck, the legs are stuck in the mud part and, my lord, the body is standing, my lord. That is why he said about mud well and she was floating upside down, my lord. This is what is correctly meant, my lord. Because the other evidence,
how can your leg be stuck in the mud when you're floating upside down?
my lord, might be that he, thereafter, my lord, mud came up, my lord.
Mud
Because
came up.
my lord, this.
How does
this,
it matter?
my lord, this,
How does that matter whether you're floating upside down
But-
or the right side
but-
up, or how does it matter?
now, my lord, thereafter, my lord, the blood seen in the face, lips were white and stomach was swollen. Some of the witness told me that victim was killed by her stepmother. Now, here the inquest person also did not say that the accused was present there, my lord. While the inquest was
Is it
conducted.
required that the accused has to be
No,
present
no,
at the
no,
time? Then
no,
how does
that-
it matter?
That I'm not placing, but as far as the other part which the learned public prosecutor placed before my lord. For that, I'm saying that she did not let the discovery. That is why I'm reading this inquest, my lord. Only on that count, my lord.
Her case is beyond that now.
Yes, my lord.
Her case is not with regard to the discovery of the body on the basis of any disclosure. Her case is now based on the extrajudicial confession and the last seen theory, only on those two
That
aspects.
is why, my lord, I'm reading the cross part for only that purpose, my lord. Now, my lord.
Then don't go into upside down.
Then, yes, my lord.
Okay, It
It
has got no relevance
My
to
lord.
the case.
Now, my lord, cross part. No GD entry was or PS case number is written in the inquest report prepared by me. The dead body was found from the village number so and so. The dead body was found at 77 at 9:30 AM. Inquest was prepared by myself in presence of OC Lamding PS. Approximate date and time of the death was 17/1/17 at about 6:30 AM. At the time of inquest, Malika Khatun, Abdul Nazir Mohit and Mohit Ali were present. So, my lord, the other persons who have said that she made the confession and she led to discovery, my lord, those were not there at the time of inquest, meaning thereby that the extrajudicial confession was not there of the lady concerned, my lord. Because witness 2 and 3,
What? I don't know, I'm not following you.
my lord, at the time of my inquest, now cross part, my lord, at the time of my inquest, Malika Khatun, Abdul Nazir, this PW4 and Mohar Ali were present. Then Saiful Islam 2 and 3 were not there, my lord. And
So how does it matter?
so now, my lord, if I come here, my lord, in the cross part of the first IU, my lord, first IU, my lord, then he says that people directly brought before the police station,
Brought whom?
the accused.
Then how does that have any relationship with the inquest? Inquest is a separate thing altogether.
So that is
Then-
my lord, the
Don't
confession.
try
made-
to confuse.
My lord,
The more you try to confuse the issue, which was quite simple, I thought at least. Now we're got to start thinking otherwise also.
So my lord, my respectful submission before this honorable court is that the persons who caught hold the accused persons, my lord, in fear if that confession is made, my lord, that would not be taken as an
How do you know
extrajudicial-
there was in fear?
Because, my lord, the IO says that the people caught hold of her. My lord, if people have gathered somewhere, my lord, because in the 313 she has denied that I have not made any confessions, my lord. That is what she has denied, my lord. I have not made any confession for any person, my lord.
So that is only an explanation.
But that apart, my lord, the confession has to be voluntarily, my lord. Then, my lord, she could have taken to, that is why I'm placing two judgments, my lord. First is the three-bench judgment of the Supreme Court, my lord, reported in, my lord, 2009-14 SCC 400, my lord. The 2009-14 SCC, page 400.
Page
Internal page 2, my lord, para 6, my lord.
2400.
While certain Supreme Court decisions were relied while taking the judgment, para 6, my lord, internal.
Yes,
This court held that, para 6 I'm reading, my lord, in so and so judgment, my lord, this court held that evidence in form of extrajudicial confession made by the accused to witness cannot be always termed to be a tainted evidence. Corroboration of such evidence is required only by way of evident caution.
para six with, starts with in Rao Shiv.
In Rao, with the judgment, my lord,
Ah.
the judgments were relied, my lord,
Ah.
and the Supreme Court has, my lord, thereafter, all these are extrajudicial confession judgments, my lord. This court held that evidence in the form of extrajudicial confession made by the accused to the witness cannot be always termed to be a tainted evidence. Corroboration of such evidence is required only by way of abundant caution. If the court believes that the witness before whom the confession is made and is satisfied that the confession was true and voluntarily made, then the conviction can be found on such evidence alone. In Narayan Singh versus State of MP, reported in so and so, this court cautioned that it is not open to the court trying the criminal case to start with a presumption that extrajudicial confession is always a weak type of evidence. it would depend on the nature of the circumstances, the time when the confession is made, and the credibility of the witness who speaks for such a confession. The retraction of extrajudicial confession, which is a usual phenomenon in criminal cases, would by itself not weaken the case of the prosecution based upon such a confession. In so and so, in Kishore Chand versus State of Himachal Pradesh, this court has held that an ambiguous extrajudicial confession possesses high probability value, whose at its inmates from the person who committed the crime and is admissible in evidence provided it is free from suspicions and suggestions of any falsity. However, before relying on the alleged confessions, the court has to be satisfied that it is voluntary and it is not a result of inducement, threat, or promise, and we says under section 24 of the Evidence Act, or was brought in suspicious circumstances to circumvent section 25 and 26. This court is required to look into the surrounding circumstances to find out as to whether such confession is not inspired by any improper or collateral consideration or circumstances of law suggesting that it may not be true. All the relevant circumstances, such as the person to whom the confession is made, the time and place of making it, the circumstances which was made, have to be scrutinized. So, my lord, they say that the lady, once they went to the house of the accused, my lord, their accused said that, yes, I have killed her by throwing her into the well. But the IO states that, my lord, she was directly brought to the police station. So the point where she made this extrajudicial confession has not been brought on record by the prosecution, where these statements were made, either near the well or at the police station or at the house of maternal house of the accused person. So, my lord, this part is missing, my lord. The second judgment which I'll place before your lordship also.
Where is it required to be stated that it was done in a particular place?
No, my lord. We caught her somewhere. There she said, thereafter it led to the recovery, my lord. So, my lord, if my statement leads to a recovery from a particular place where I am also there, along with the police and the witnesses who are deposed before the court, then, my lord, that extrajudicial confession gets in confidence of the court, my lord. But the witnesses along with the persons, my lord, have not gone to the well, neither they state that where she has stayed, whether she has stayed at her house or near the well or at the police station, my lord. That part has to be there because she was caught, my lord, by certain person. That has come as evidence on record, my lord. So for that I am saying, my lord, that this extrajudicial confession which the, my lord, learned trial court has relied has not come, my lord, in a proper perspective, my lord. Because those witnesses, neither they were present at the time of inquest, my lord, neither they were present at the police station, my lord. Because the IO in the statement says that person who brought her to the police station, I have not stated the names of those persons, my lord. This is what the IO has stated, my lord. PW 6, my lord. Last part, my lord. We found that some person brought the accused Fatima at Narcotic Patrol Post, but by whom she was brought at Narcotic PP, I have not mentioned the name of those persons. So, my lord, had that been PW 2, 3, 4, my lord, then he could have mentioned the names. But he has not mentioned the name of the persons who have brought her to the police station. Meaning thereby that where did that lady made their extrajudicial confession? Because the extrajudicial confession is made before the witnesses who have deposed before the court. But the IO never says that before these persons she has made. And in the cross part,
How does it matter, sir, if the IO doesn't say? When one of the persons who has heard it has said it.
because, my lord, the IO is the person who has recorded the statement of the witnesses, my lord.
So,
And he says that PW2 Sheffield did not state before me in the cross part. This IO says that
four,
he did not state me.
what about four?
Was going
What
with so and so.
What about four? What did the IO say about four?
Yes, my lord. Last part, it is a fact that witness Abu Nazir Wahid did not state before me that informant Malika Khatun did not tell me about the missing of the victim girl, but did not say that she made an extrajudicial confession.
You did not ask that question to the,
Yes, that is there. Page 16, my lord, cross part. I did not question the accused.
no,
This
no.
PW4, page 16, my lord. Page 16,
You did,
PW4.
you did not question PW6.
No, my lord, PW4, my lord, PW4 kindly, because I directly asked PW4, my lord, Abdul Wahid Nazir. Page 16, my lord.
Yes,
Now page 17 is the cross part, my lord.
yes,
Last three lines of the cross, my lord.
yes.
I did not question the accused.
Okay, he did not question, but he
So
heard
where from-
someone question.
So where from the extrajudicial confession comes, my lord, if I have not talked to a person concerned? Where from that question of extrajudicial confession will come if I have not talked to a person? I need to interact the person. Have you killed somebody? Yes. Then, my lord, it becomes an extrajudicial.
What happens if supposing the person besides me asks him and I heard and I hear, then what happens?
Then, my
Then
lord,
it doesn't,
then,
will that be an extrajudicial confession? Supposing I hear someone making a confession,
yes, my lord.
but supposing there are three of us, supposing there are three persons, and one of the three persons asks the question to that accused, and the accused makes an answer, and I have heard it. All three of us have heard it, but I did not make the question. Is it required that all three of us have to ask the question?
No, my lord.
Then-
My lord is very correct. But, my lord, the reply to your lordship answer would be that by the time I was at the well, I was not at the police station. Because the inquest, the executive magistrate said that three persons there with me. Malika Khatun, this PW4, Abdul Wahid Nazir and Mohar Ali. Meaning they are the persons who caught hold over the lady at the police station were persons different, my lord. Where from that extrajudicial confession will come then, my lord?
No. Why? He was there. This person had gone to the well also.
No, but he was not there at the police station then, my lord.
How does it matter if he's not there at police station?
That's my
So
lord.
someone else can bring. I did not be there. I did not be everywhere.
No, my lord.
This person,
My lord, this, my lord,
PW4 does not have to be everywhere.
my lord, my other part is that, my lord, this is what Supreme Court says in the other judicial, that, my lord, if there are two possible views, my lord, then, my lord,
There are no views out here. There are no two possible views.
yes, my lord, here in this case, my lord.
They are trying to make out two
they
possible
could
views.
they could not even prove, my lord, then, my lord. Second judgment which I'll place, my lord, is, my lord, reported in 2019, 16 SSC page 91. Here, my lord, 16, my lord, confessions, my lord, extrajudicial and, my lord, judicial. confession are
2019.
explained, my lord. 2019, 16 SSC page 91. Because, my lord, this case, my lord, under three heads, my lord, the accused has been convicted. One is extrajudicial, the other one is circumstantial evidence, and the third one is Lassen theory, my lord.
They are 2009, not 19.
16 SCC, my lord. 2009, 16 SCC, page 91.
Hmm. Yes,
Internal page 3, my lord, para 7.
yes,
May I read, my lord?
yes.
Confessions may be divided into two classes, judicial and extrajudicial. Judicial confessions are those which are made before a magistrate or a court in the course of judicial proceeding. Extrajudicial confessions are those which are made by the party elsewhere than before a magistrate or court. Extrajudicial confessions are generally those that are made by a party to or before a private individual, includes even a judicial officer in his private capacity. It also includes the magistrate who is not specially empowered to record confession under section 164 of the Code of Criminal Procedure, or a magistrate so empowered but receiving the confession at a stage when section 164 of the code does not apply. As to extrajudicial confessions, two questions arises. Were they made voluntary? Are they true? As the section enacts, a confession made by an accused person is irrelevant in criminal proceeding if the making of the confessions appears to the court to have been caused by any inducement, threat, or promise. Having reference to the charges against the accused person proceeding from a person in authority and sufficient in the opinion of the court to give the accused grounds which would appear to him reasonable for supposing that by making it, he would again gain an advantage or avoid an evil of a temporal nature in reference to the proceeding against him. It follows that a confession would be voluntary if it is made by the accused in a fit state of mind, and if it is not caused by any inducement, threat, or promise which has reference to the charge against him proceeding from a person in authority. It would not be involuntary if the inducement does not have reference to the charge against the accused person, or B, it does not proceed from a person in authority. It is not sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making he would gain an advantage or avoid any evil of temporal nature in reference to the proceeding against him. Whether or not the confession was voluntary would depend upon the facts and circumstances of each case, judged in the light of section 24 of the Evidence Act. The law is clear that a confession cannot be used against an accused person unless the court is satisfied that it was voluntary, and at that stage, the question whether it is true or false does not arise. If the facts and circumstances of the case surrounding the making of a confession appears to cast a doubt on the veracity or voluntariness of the confession, the court may refuse to act upon the confession, even if it is admissible in evidence. One important question in this regard to which the court has to be satisfied with is whether when the accused made the confession, he was a free man or his movements were controlled by the police, either by themselves or through some other agencies employed by them for the purpose of securing such confession. The question whether confession is voluntary or not is always a question of fact. All the factors and all the circumstances of the case, including the important factors on the time given for reflections, scope of the accused, getting a feeling of threat, inducement or promise, must be considered before deciding whether the court is satisfied that in its opinion, the impression caused by the inducement, threat or promise, if any, has been fully removed. A free and voluntary confession is deserving of the highest credit because it is presumed to flow from the highest sense of guilt. It is not to be convinced that a man would be induced to make a free and voluntary confession of guilt so contrary to the feelings and principles of human nature if the fact confessed were not true, deliberate and voluntarily. Confession of guilt, if clearly proved, are among the most effectual proofs in law. An involuntary confession is one which is not the result of the free will of the maker of it. So where the statement is made as a result of harassment and continuous interrogation for several hours and the person is treated as an offender and accused, such statement must be regarded as involuntary.
This petition talks about judicial confession.
But my lord, people have gathered, my lord, they have caught the accused person. So my lord, that part is there. So my lord, it cannot be said that my lord, it was voluntary, my lord. Then on my lord,
Is it, this talks about
yes, my lord.
when the voluntariness of confession in relation to police and the agencies, not with regard to confession made to a private individual.
My lord, that part is correct, my lord. But what I am on is that, my lord, he was captured by certain persons, my lord. And my lord, in fear of my lord being assaulted or my that part, my lord. If certain statements are made, my lord, that cannot.
What was she doing for the last 2 days?
Well, she was at her mother-in-law house because she had a quarrel. That has come on evidence, my lord.
She had a forum.
She had a quarrel.
And then her 4-year-old child, when a child goes missing for a few hours, what does the mother, what did she do?
My
I
lord,
mean, you see, if you had a 4-year-old child, which I think you have had. If it goes missing for 1 hour or so, I think you'll be in panic mode.
now, my lord, what
What
My lord,
any
I-
explanation given by?
my lord, that is what I'm saying, my lord. One daughter goes and one daughter comes, my lord.
What was it?
In some of the evidence, a person says that she went with Khudeja, but she returned with her own daughter. She did not return with Khudeja. But my lord, the evidence is not at all there in the entire case that Fatima ever came down to her in-laws house after she went to the maternal house. That evidence is never there, my lord. And for the first time she knew about that, my lord, when the grandmother-in-law came to her place and she revealed that Khudeja is missing, my lord. And since, my lord, somebody is tagged and accused, my lord, her efforts would always be hidden, my lord. Now, my lord, as far as circumstantial evidence is concerned, may I please certain judgment, my lord?
You are going to give the same, that they have to form a complete chain or
Yes, my
link.
lord, my lord,
Yes.
true, my lord, true, my lord. Well, that's a surrogate we didn't. And these are recent, my lord, otherwise these are recent, but I,
If the fact situations are similar,
yes,
then
madam.
it's okay.
Then, my lord.
Otherwise, we are reiterating the same old thing
Yes, my lord.
over and
And
over
last
again.
intro he has come up from the lordship, my lord. 2 days prior, my lord, she was seen, my lord, not on 17, my lord. That occurred after 2 days, my lord. This is my mother.
So this, yes.
Lordship, just how far your lordship may rely on the case diary under
One
section
thing is, one thing
my lord.
is, when did the child go missing?
15.5, my lord,
15-1.
15 one.
15.1.
The
15.
child went missing on
Yes.
15 one.
First of all, the accused person denied about when she was questioned, she denied, my lord, then thereafter she confessed.
If she was missing on 15 one, what did the mother do for the next 2 days? She was not worried.
My lord, the thing is in.
Some say she is the stepmother, some says aunt.
She's the stepmother.
She is a
Some
stepmother.
says, but
He's
some
a, he is
says,
a stepmother, my lord.
yes.
But then that is the surprising part. You see, if a child goes missing, actually, if there was any love and affection, I mean, you'd immediately be in panic mode. And for a child of 4 years to be missing for even a day is quite abnormal. And for 2 days is even more so.
That is why I pointed out in the first part, my lord, the investigation are completely defective, my lord. The IO did not even, my lord.
No, I'm not talking about the investigation.
But
I'm
those
talking
parts
about,
should have
I'm
been
talking
there.
about your reaction.
Yes, my lord, my reaction, but my lord, if I'm
It's our
accused, my lord,
conduct.
Huh?
whatever
Our
good I'll do,
conduct.
my lord, those will be hided, my lord. Whatever good I'll do, my lord, those will be hided always, my lord. Because I'm seen as an accused, my lord. If I make an efforts also, my efforts, none of
But
the
you
witnesses will come up and say
could
that.
have given an explanation under 313.
My lord, that was, the question was not there, my lord. The question was not there, my lord. It has to be put by the court, my lord.
You could have maybe given they brought in a defense witness, so you could have also given evidence.
But my lord, in criminal proceedings, my lord,
Huh?
it is not, my lord, that I need to adduce evidence, my lord.
It
The
is not
prosecution
required,
has to
but you
place-
could to
case.
clarify. You are not giving any explanation even now in appeal
But my
as
lord,
to what you
the
did for 2
the
days.
explanation which I'm giving is only that, my lord, even if I'm targeted as an accused, my lord, the good things if I'm doing, my lord, those will be hidden, my lord. None of the witnesses will come up and say that she also made an efforts, my lord. But as far as my submission, my lord, I'll say that I have taken all the efforts, my lord.
Is anything what?
Lordship, regarding the reliance of the case on, up to what extent your lordship may rely on the case diary, section 172 of the CRPC. Lordship is aware of it. no? Diary of proceedings in investigation.
Two minutes, madam.
Yes.
We just get up for 2 minutes.
Lordship, may I take your lordship to the provision of CRPC, the
Yes,
section 172?
yes. Yes,
Diary of proceedings in investigation. Every police officer making an investigation under this chapter shall day by day enter his proceedings in the investigation in a diary, setting forth the time at which the information reached him, the time at which he began and closed his investigation, the place or places visited by him, and a statement of the circumstances ascertained through his investigation. The statements of witnesses recorded during the course of investigation under section 161 shall be inserted in the case diary. The diary referred to in subsection 1 shall be a volume and duly paginated. Any criminal court may send for the police diaries of a case under inquiry or trial in such court and may use such diaries not as evidence in the case but to aid in such inquiry or trial. Just to aid for inquiry and trial. Neither the accused nor his agent shall be entitled to call for such diaries, nor shall be or they be entitled to see them merely because they are referred to by the court, but if they are used by the police officer who made by them to refresh his memory, and if the court uses them for the purpose of contradicting such police officer, the provisions of section 161 or section 165, as the case may be of Indian Evidence Act, so and so shall apply. So for the limited purpose only.
okay. Okay, right. Heard, Mr.
A. Tiwari, Lord.
Huh?
A. Tiwari.
A. Tiwari, Learned Amicus Curiae, and Ms. B. Buyan. Addition PP. Hearing concluded, judgment reserved.
Deeply obliged, Your Lordship.
That upgraded case for that matrimonial.
Your lordship may peruse the last order, my lord. It is a matrimonial appeal, my lord, filed by the husband, my lord. So on last occasion, my lord, they were asked to appear personally before your lordship, my lord. Because.
Then you're the appellant.
Yes, my lord.
You want a divorce
Yes, my lord.
and now why was you have been called to this court
Yes,
for the purpose of attempting a
mediation.
mediation failed, correct?
Yes, my lord.
Mediation failed. Is it mediation failed?
Yes.
So is there any chance? Do you all want to try? Do you want to speak in the chamber? That can be done or
It may be taken up in chamber, madam.
chamber? Okay, we'll take it up in the chamber. You want to take it up now?
Yes.
Right, then we'll take it up in the chamber now itself. But is there a chance of, is there some common ground that we can meet?
Yes, my lord.
Mr.
My lord,
Bora.
the contention of, we have filed the appeal basically on the ground that, my lord, the contention and the evidence of the petitioner as well, his mother was not at all considered by the learned trial court. Now, my lord, because his contention is that because she wants that, she doesn't want to stay with him and she doesn't want to give divorce. That is her contention.
Well, is
That
that
is my
true?
personal hearing maybe.
No, is that true?
My lord, she wants to stay.
Only that part,
only
only
the
that
mo-
part. He is saying, Mr. Bora is saying that the
Goalpara, my lord. My lord, here, the affair was lost. My lord, in paper book page 4 is the affair, man.
yes,
My lord, I am reading the affair.
yes,
I have the honor to state that my third daughter, Anisa Begum, had been in love affair with Babu Ali, son of so-and-so, resident of so-and-so for about 1 year. But unfortunately, my daughter was brutally killed last night at a place about 100 meters away from the house. I suspect that Babu Ali had committed this heinous act. I therefore earnestly pray to your good self to investigate into the matter and take necessary action. And accordingly, the affair was
this
registered
informant is PW number.
1, my lord.
Ah.
And case was registered under section 302, my lord. And subsequently, 34 also add, my lord. And the PW 1 is the informant, page 8, my lord.
Yes.
And charge also frame, my lord, under section 302. And
Against
trial
five-
was started and
Against
accordingly,
5 persons.
yes. And my lord, the PW 1 was examined. I am reading, my lord. On oath, my lord, he is saying, I lost this Azahar. I am an illiterate person. I put my thumb impression in the Azahar. Deceased Anisa Khatun was my daughter. The incident took place about 3-4 months back. The accused persons are my fellow villagers. They reside near my house. They belong to the same family. The incident took place during night hours. My daughter Anisa and I were at home. My wife was not in the house. She had gone to the house of my married daughter, so-and-so at Golpara. At about 9 p.m., accused Babu, alias Majirul, my lord, here is the respondent number 2, my lord, is the main person, came to my house. Thereafter, he sat with us. He had been in love affair with Anisha for 2 years. He was to marry her. He used to visit my house on that context. They started watching TV. I had dinner. I sat with them. Thereafter, at about 8-9 p.m., they went out saying that they would go out for a walk. I did not object. They are in love. They did not come back. Waiting for them, I fell asleep. After getting up in the morning, I found that Anisha had not come back. About 4 months prior to the disappearance of my daughter, accused Babu's father, mother, and his elder brother, namely accused Anwar, accused Jarina Begum, and accused Manirul respectively, called me and said that if Babu were to take my daughter to their house, they would kill her. They had objection in the marriage between my daughter and Babu. After getting up in the morning and offering namaz while I was going to the field to Titharkau, I saw people coming from the direction of the cremation ground and going toward the road that lead to the field. I also went with them to see what had happened. I found that the dead body of my daughter was lying in the field. I turned the dead body and saw that a chadar was tied back with 3-4 knots at the nape of my daughter's neck. I did not see any other injury on the body. I felt unwell. I do not know what happened thereafter. I lost Ejahar with the PS. Police came, prepared papers, and sent dead body to the hospital for postmortem examination. Police questioned me in connection with the incident. Material exhibit 1 is the said chador, and I have recognized it in the court today. Later, the dead body was handed over to us and we performed the last rite. I gave my statement before magistrate and I put my thumb impression on the statement. I did not meet Babu thereafter. Babu did not come to make any inquiry. In close, my lord, I have not seen any note in the chador which I have seen in the court today. Babu was to marry Anisa. The chador which I have seen in the court today is generally available in every household. There was love affairs between Babu and Anisa. In the first Ejahar, I stated that I suspected Babu Ali of the killing Anisa. I did not name the other accused persons in that Ejahar. After 2 days, I filed a complaint case in the court implicating the guardians as accused persons. Police has already registered this case on the basis of my earlier Ejahar before I filed the next complaint petition. Since Babu had come to that day, had taken my daughter away and other accused persons had threatened me, I lost this Ejahar against the accused persons. It is not a fact that I neither mentioned in the Ejahar nor stated to the police that Babu had come to my house and watched TV with Anisa, that I had sat with them after dinner and they had left saying that they would have a walk. It is not a fact that I neither mentioned in the Ejahar nor stated to police that after offering namaz, I went to the field to teeth her cow. It is not a fact that it was not mentioned Ejahar in the first Ejahar or in the second complaint case that about 4 or 5 months prior to the incident, the other accused persons had threatened me with regard to the marriage of my daughter. It is not a fact that I stated to the police that I suspected that Babu had done the killing. It is not a fact that I stated to police that none other than Babu could kill Anisa. It is not a fact that my suspicion is baseless. It is not a fact that the accused persons had not threatened me. It is not a fact that Raju's visit his watching TV with Anisha and their departure to have a walk are false statement. I touched the dead body before the arrival of the police. It is not a fact that I have falsely deposed that a chador was tied back with 2-3 knots. I did not go searching for my daughter in the night on which she had gone missing. My lord, it was the statement of PW1. Now, my lord, the PW2. My lord, here the relevant is the PW1, 3 and 4, my lord. Because the PW2 is the cousin brother. He, my lord, subsequently came next day morning. So, my lord, I think, my lord, the PW1, 3 and 4 will be relevant because they are saying that Babu, the respondent number 2, Babu came and watching TV with the girl, my lord, and after a while, they, my lord, to go out and she did not return and morning found her dead body. So, my lord, I am reading the PW3, my lord. 3 also present here. This is the brother of the deceased. On oath, my lord. The complainant is my father and deceased Anisha was my sister. I know the accused persons by their name and face. They are my neighbor and they belong to the same family. I reside with my parents. The incident took place on 2/2/2013. I was in my house that day. My father and sister Anisa were in the house. At about 8:30 to 9 p.m., accused Babu came to our house. He used to come to our house since he was in love with Anisa. They started having a conversation. My family and I were in separate house in the same courtyard. I retired to bed. Babu and Anisa were having a conversation. Afterwards, I fell asleep. There is a field behind our house. I got up in the morning and found Anisa unavailable in the house. Having seen a large number of people gathering on the field, I too went there. I found Anisa lying dead on the field. I saw Urna, that means chador, was her neck with knot behind the neck. I was other injuries. I saw other injuries. Later, the police came and after preparing report on the dead body, sent it for postmortem examination. Afterwards, the dead body was handed over to us and we performed the last rite. The red and black chador found with the dead body belonging to Anisha and I will be able to recognize it if I see it. Material exhibit 1 is the said chador. I have recognized it today in the court. Accused Babu had killed Anisa. Police questioned me. I made my statement before magistrate under section 164 CRPC. Exhibit 4 is my statement made before the magistrate. Exhibit 4.1 and 4.2 are my signature. In close, my lord, I stated in the statement that Urna, that means chador, was knotted around her neck. By Urna and chador, I have meant the same. I did not see note in material exhibit 1, chador like this is available in other household also. We suspect Babu as he had been in love with Anisha and had come to our house on the night of the incident. It is not a fact that I did not state to police that I had seen Babu coming to our house and having a conversation with Anisha. It is not a fact that I did not state to police that I reside with my family in a separate house in the same courtyard. It is not a fact that I did not state to police that I had seen the chador knotted around the neck of Anisha. It is not a fact that I stated to police that since Babu had been in love with Anisha, we suspect that Babu was involved in the incident. It is not a fact that the material exhibit 1 was not found on the day. It is not a fact that I have adduced false evidence. He is the brother of the deceased man and PW1 is the father. And now on a PW4 is the wife of PW3 man. That is called Bhabi of the deceased man. And her statement is very vital man. PW4 my lord, I am reading.
Yes, sir. PW1 is the father, correct?
Yes, my lord.
PW2 is the
PW the cousin brother.
cousin brother, and PW3,
3 is the my lord, the own brother of the deceased.
brother of disease. And 4,
4 is the my lord, the sister-in-law. That means wife of his wife of her brother.
Wife of PW3.
okay, okay. So sister-in-law. Sister-in-law of disease.
Yes, my lord. She also stay in same campus. Now, my lord, she is saying that when the accused person came, page 16 is the my lord PW4. The complainant is my father-in-law. That means Shashul. I know accused Manirul and Babu, alias Majirul. That boy, my lord, who was in love, his name is Babu and original name is my lord Majirul. I also know the absent accused persons. I know deceased Anisa Khatun. She was complainant's daughter and my sister-in-law. The incident took place about 1 year back. My husband Rajiv, father-in-law Anwar Khan, mother-in-law Rahibun Khan, and I reside in the house, among others. I have a 4-year-old daughter. We reside in the same house, but in separate rooms. My husband, our child, and I reside in a room. Anisha had been staying alone in a room. And my father-in-law and mother-in-law reside in another room. My sister-in-law was not married at that time. That means deceased. The accused persons and we reside in the same village. Their house is situated some 5 or 6 houses apart from ours. The incident took place at night. I was in the house. My husband was not in the house. He had gone to market. My mother-in-law had gone to the house of her another married of daughter at Golpara. At about 3 p.m. that day, accused Babu made a phone call to Anisha over mobile phone. When I asked Anisha, she told that Babu had made the phone call. They were in love and they often used to talk over phone. I do not know what the conversation between them was. At about 7:30 p.m. that day, accused Babu came to our house. At that time, Anisha was watching TV in her room and Babu entered into the room and started having a conversation with Anisha. They continued the conversation. They were engaged to each other. After a while, I entered the kitchen to prepare food. They continued with their conversation. After a while, my 1.5-year-old daughter woke up and I fed her milk. I fell asleep. After a while, I woke up and went to the kitchen again to cook food. They were still conversing with each other. After a while, they went out of the house saying that they would go out for a walk. I kept cooking food at about 9:15 to 9:20 p.m. My husband came back from the market. Till then, neither Anisha nor Babu had returned. After having the dinner, I locked the door, supposing that she would come, she would call me after coming back. Thus, they walked around together at night. I got up 5:30 a.m. and found that Anisha had not returned home. I made inquiry in the neighboring household, but I did not find her. At about 6:30 to 7 a.m. that day, my father-in-law saw many people going to the field behind our house, and they said that a dead body of a camel was found on the field. My father-in-law told this to me. I went there and saw dead body of Anisha. A shawl was fastened around her neck. Shawl, that means chadar. A lock was found on her right wrist. It was hook of the chain of a jacket. Later, police and magistrate came and prepared report on the dead body. I will be able to recognize the shawl if I see it. Material exhibit 1 is the said shawl. I have recognized it. It was fastened around Anisha's neck. Later, police sent the dead body for the postmortem examination. Afterwards, police produced me before the magistrate and I gave my statement. Exhibit 5 is my statement and exhibit 5.1 and 5.2 are my signature. I came across police. Subsequently, the police did not ask me anything. At about 3:30 to 4 p.m. on that day, about 4 or 5 months prior to the death of Anisha, Babu's mother Jarina, father Anwar Hussain, elder brother Jahirul, and younger brother Monirul had come to our house and told us that they would not accept Anisha as the wife of Babu, and that if Babu were to marry Anisha without their consent, they would kill Anisha. Jarina had said that they would kill her. After 2 months prior to the death of Anisha, they had come to our house once again. Again they came. They came at 9:30 to 10 a.m. My mother-in-law was in house. My father-in-law was doing his work. My husband was in house. They said that they would not accept Anisha as their daughter-in-law. No quarrel took place, but Babu was adamant on marrying Anisha. Mark of rape was found on the dead body at the time of giving a wash to dead body. Mark of rape was found, she say. In close, my lord, she stated that we had common dining arrangement. Ours is a joint family. Babu was to marry Anisha. Material exhibit on is a shawl which may be available in other household also. Police did not question me. It is not a fact that police questioned me and that I neither stated to the police nor in exhibit 5 that Babu was talking to Anisha that I was cooking food in the kitchen. That when my daughter woke up, I feed her milk. That I slept thereafter. That later when I was cooking, they went out of the house after talking to me. That I saw them having a conversation that about 4 or 5 months prior to the incident, Babu's mother and other accused persons had come to our house and made a threat that they would kill Anisha, that they would not accept Anisha as their daughter-in-law. At that about 10 a.m. that day, about 2 months prior to the incident, they had come to our house again and said the same things that I saw shawl on the neck of Anisha and that the lock of the chain was found in the right first of Anisha. It is not a fact that I stated to the magistrate in the following manner. At about 11 p.m. on the previous day of the incident, I retired to bed after watching TV in the room of Anisha. Anisha also retired to bed. On getting up on the following day, I found that Anisha was not available in the house. Malad, total 8 numbers of PW was examined, including IO and the doctor Malad. Malad, these 3 is the vital. Other Malad only they came to the morning when the dead body was recovered. So Malad, these 3.
So what is the link between the death of the deceased and the respondent? What is the link?
Malad, in this case, Malad, the PW1, PW3 and PW4, they are saying that Babu came and there was a conversation between them and she go Malad with him Malad. And there is a last scene theory Malad, this is the case Malad.
What
Otherwise, no eyewitness that when she was killed. In doctor Malad, report kindly Malad, I am reading Malad.
So your case is what? That Babu killed her
Yes, Malad.
or the family killed her? Who?
Malad, the investigation Malad submitted this way that the family member came and threatened earlier.
No. That is your case.
Therefore, Malad, the
That is-
whole
that-
family
that
was
is-
charge sheeted, Malad. Yes.
Charge sheet you can charge sheet everyone. What is your case? Your case is that the whole family killed her or only Babu killed her?
Malad, I think Malad, the Babu maybe. Malad.
How? What is
Because,
the only
Babu-
last injury? Only
Babu,
that.
Babu came and taken her Malad at night and
What is the explanation given by him?
alive of the deceased Malad.
Any explanation given by him?
Malad.
Any explanation given by Babu?
Babu Malad, he totally denied Malad. In 313 Malad, Babu said that everywhere false. The question was put that
He was there? No, he was there. Patient was not patient. Yes, it's very good. It is not an- Patient must have been responded by the police. I don't know what explanation that is. But I just want to think. It is the since you will probably must be with an improved story in the code. It is a contradiction. Contradiction is good to buy more. Huh? That Babu came at night
they were talking, etc. These are totally contradiction. Contradiction has been proved to IAS. These are improved story. These are not in 161, neither in.
Not in 161. In the 161, there is no statement made by them. That he came at night and they took them out. But they have not been confronted with that. one. I will be confronted.
W1, we vote on a control.
So he did not come at night.
No.
So she was found. And what about that that zipper, something locked?
There is no investigation to that.
There's no investigation.
No investigation.
No, nothing was verified with regard to whose jacket, whose zipper or whatever.
Well, the page 23, well, the opinion of the doctor, well.
No, opinion doctor, how does it matter?
In my opinion,
Okay, she died due to whatever reason. We want to know who committed the murder.
my lord, strangulation by sheet of cloth which was antemortem in nature.
Yes, okay, that is all right. Now let us go to the IO's evidence.
I was evidence, my lord, so that is
Page 25.
page, my lord, 25, my lord.
Yes.
PW 8, my lord. Well, on 3/2/2013, while I was serving in Krishna police station, the OC of the PS registered a case on receipt of exhibit 8 Ejahar from Anwar Khan and entrusted me with the charge of investigation. Hakim Ali was the officer in charge. Exhibit 8(1) is the signature of Hakim Ali, which I am familiar with. I questioned the complainant. Prior to that, a GD entry number so and so was made. I visited the place of occurrence on the basis of that. I visited the place of occurrence on being shown by the informant. It was an agricultural field beside a dried up pond. I found there a dead body of a girl aged about 22 years. The dead body was clad in a black pajama, a red colored top, and a woolen pullover. A woolen shawl was found fastened around her neck with knots. Having found a black shawl, a damaged old seal, a broken chain lock, a blue colored round nylon string, and a silver colored bottom type, I seized the same through exhibit 2. And the sigil list of exhibit 2 and 2 is my signature. Material exhibit 1 is the woolen shawl. Material exhibit 2 is the nylon string. Material exhibit 3 is the damaged seam, and material exhibit 4 is the broken chain lock, and material exhibit 5 is the silver colored bottom. I took the statement of the witnesses. Executive magistrate held inquest on the dead body. Later on, the dead body was sent for the postmortem examination. It was the dead body of Anisha Khatun, alias Khanom. It was identified by Imran Hussain. Later, the complainant identified the dead body to be of his daughter Anisha. I sent Masoom Khan, Rajiv Khan, Jonali Begum, and complainant Anwar to the court for recording their statement. Exhibit 9 is the sketch map of the place of occurrence. Exhibit 9(1) is my signature. A mobile phone of the accused Babu Ali was seized through exhibit 10, and exhibit 10(1) is my signature thereon. I arrested accused persons, Babu Ali, alias Babu Hussain, alias Majrul Hussain, in connection with this case. Rest of the accused persons were absconding. I could not arrest them. After completing the investigation, I submitted charge sheet of offense under section 30234 IPC. Exhibit 11 is the charge sheet, and exhibit 11(1) is my signature. As per the CDR, Majrul Islam called Anisa,
Who is Mozarul Islam?
that accused, my lord.
Mozarul Hussain.
Babu. His 3 names, my lord. As per the CDR, Majidul Hussain called Anisa over phone 4 times from 8:20 PM to 1:47 AM. In the night of the incident, madam. That is very important, madam. Exhibit 12 is the CDR of 2/2013 with intervening night of 3/2013 under objection. Exhibit 13 is the incomplete sentence ballot. It is not translated. 1/3/2013. Call was made at 1:24 AM. And the call duration was 291 seconds. Call was made at 1:43 AM on the same day, and the call duration was 139 seconds, 139 seconds. Call was made at 1:47 AM, and the call duration was 45 seconds. There were 3 calls on second day of the month. Call was made at 1:57 PM and call duration was 1,647 seconds.
You see, the call was made on 1:57 PM. That
Yes,
means
ma'am.
in the afternoon.
Evening ballot, first,
Huh?
Of the previous day.
Of the call was made,
the date of incident ballot.
there were 3 calls on the second day of the month. Second day of the month, you see, second day of the month, he came to the house at 9 o'clock as per the evidence of PW1. And call was made at 1:57 PM, that means in the afternoon.
Yes, madam.
Then, then thereafter, on the same day, call was made on 3:19. That is again before 9 o'clock. And then again, call was made at 3:27 PM and it was for 42 seconds. So 3:27 PM, all these are before he came to the house, before Babu came to the house. So what is there? There's nothing wrong with this calls.
Ballot, one sentence here, as per CDR,
Hmm.
Majidul Hussain called Anisa over phone 4 times from 8:28 PM to 1:47 AM
Where are
in
you
the night
reading?
of incident.
Last but one paragraph.
Ballot, from bottom ballot, second para. Page 26, ballot.
Page 26.
Page 26. Paragraph, it will be.
In the
four-
night of incident.
Yes, madam. It is very important, madam. Because the incident happened during this time, madam. In fact, that Babu, my lord, had to reply under section 313. That she came with me and subsequently she returned back. But her statement is total deny. No, she did not come. But,
Exhibit 12 is the CDR of 2/2013
But there is no certificate as required under.
or 65B. Oh. Section
That
65B
problem is there.
of the Information,
Evidence.
Evidence.
the Evidence Act. Okay.
It is a corroborative, madam. If corroborated, it will get value, madam.
65B is necessary.
Neither anyone from the nodal.
But the case of last seen theory, my lord, here. Because no eyewitness.
Let us carry on reading the evidence.
Yes, my lord, I am finishing that page 27, my lord, I am
Yes.
coming. My lord, last pair of my lord, page 26, my lord. Exhibit 13. My lord, 3/2/2013, call was made at 1:24 AM and call duration was 291 seconds. Call was made at 1:43 AM on the same day and call duration was 139 seconds. Call was made at 1:47 AM. The call duration was 45 seconds. There were 3 calls on the second day of the month. That means that is the day of incident. Call was made at 1:57 PM and the call duration was 1,647 seconds. On the same day, call was made at 3:19 PM and the call duration was 214 seconds. And again, call was made 3:27 PM and the call duration was 42 seconds. Many calls were made that day and phone call came from side of the boy. All the phone came from side of the boy. The mobile phone number of the accused Majirul is so and so, and that of the victim is so and so. The accused person's mobile phone was found while the victim's phone could not be traced out. The mobile phone with SIM card and the above noted mobile phone of the accused were seized through Exhibit 10. The witness stated that the said mobile phone belongs to Babu Ali alias Majirul. Material Exhibit 6 is the seized mobile phone of the accused Babu Ali. There were regular call between them. I only collected the CDR of the above dates. On contacting mobile agency, it was learned that on the day of occurrence, the mobile of the accused was active at Manikpur area. I have not submitted any paper in the case to show that the mobile was active at Manikpur. Prayer was made for CDR, but the copy thereof has not been enclosed with the CS. The CDRs were not certified by any company and the same have not been given in the CS. Exhibit 12 and 13 are photocopies. I did not get the ownership over the mobile of Majirul ascertained by company. Copy of Exhibit 10 was given to the accused. Babu Hussain was written there. It is not written that it was received. I took a statement of Imran. The recovery of the dead body and the seizure of the articles were made on the basis of GD entry. The mobile was seized in the PS case number GD entry number 43 dated 3/2/2013 is in the CD. Therefore, the separate extract copy has not been submitted in the case. The finger print of the accused Babu Ali was taken, but copy was not given with the CS. The complainant identified the dead body at the time of inquest. I found the phone number of the victim from the statement of the members of the family. I did not get that number authenticated by company. There were not in the shawl in the neck. The tongue remains pressed against teeth. The place at Manikpur, where the dead body was found, is the residential area. The house of the complainant is in eligible. There was a market in the northeast. There was a brickyard in the southeast. I recorded the statement of the neighbors, namely Habib, Ansir, Rafiul, Islam, and Nobi. But I did not mention in the case diary the distance between their house and the place where the dead body was found. It was not be identified of those whose cloth, the same lock, and silver colored bottom wear. I did not write down the measurement of the nylon string. The SIM card was a damaged one, and the name of the mobile company of the SIM was not ascertained. After holding the inquest on the dead body, it was sent to hospital for postmortem examination. In that condition, it is not a fact that the mobile phone was not seized from the accused Babu. I took the statement of Anwar Hussain on 3/2/2013. Later, when the complainant filed a case in the court, And when the court forwarded it to the PS, I examined it for the second time. In his first statement, Anwar just suspected that accused Babu had killed Anisa. In the subsequent statement, he stated that accused had killed her. On 6/2/2013, the same complainant filed a complaint case in the court. On 7/2/2013, I made a prayer to the court for amalgamation of the cases. Thereafter, I examined the complainant once again. Except for witness Abed Ali mentioned in the complaint petition, I examined the other witnesses on the basis of Ejahar. The name of Monirul Islam, Jahirul Islam, Anisa, and Jarina were newly included in the complaint petition. In the FIR will not mentioned subsequently when filed the complaint before the court, then co-accused persons mentioned in the FIR. In this statement, witness Anwar did not state that accused Babu had come to his house, that accused Babu had watched TV with Anwar, that Anwar had sit with them after taking dinner that day. They had gone out saying that they would go out for a stroll and that Anwar had gone to teeth her cow after offering namaz. Anwar stated that accused Babu had killed her as accused had affair with her. Witness Masum Khan did not state to me that lock chain was of the jacket of the accused Babu, that the damaged SIM card belongs to Anisa, that he had seen lock chain in the hand of deceased Anisa, that he had seen accused wearing the jacket, that lock chain was of that jacket, and that 2 months prior to the incident, the complainant had told him that accused Babu had love affair with Anisa. He stated that he suspected that accused Babu had killed Anisa since Babu had love affair with Anisa. In his statement, witness Rajiv Khan did not state that he had seen the accused Babu coming to his house and conversing with Anisa, that he had resided in the separate house sharing the same courtyard, and that he had seen a chador knotted around the neck of Anisha. He stated that he suspected so. In her statement, witness Jonali
Now,
Begum.
I think we have all read this. Basically, the IO has denied that the witnesses had made their statements, which the contents of their evidence in their 161 statement.
Yes, ma'am.
So,
But if only the last scene together is considered as the
but
statement of
then,
PW one.
but then
three,
that
and
last scene together also is in doubt now. Because last scene together, the witnesses have not stated in their 161 statement. Only in the evidence they have stated that. In their 161 statement, they never told the police.
Yes.
Only now for the first time, they have stated this.
161 has not stated. Yes, I have seen those.
Then
But
jacket also that lock chain, that also not proved.
only Melot, this much is proof that he came Melot and telephonic conversation was that day.
No,
So,
telephonic conversation was there.
So,
Telephonic
Fine.
conversation was there, but
and Melot last scene together, if we believe, then it is the corroborative witness of that telephonic Melot.
no, but then you see, if they are last seen together, why should they be telephonic conversation? If you are with your girlfriend side by side, why did you talk on the phone? You talk directly while you use the phone to talk. That is the problem. Yes, madam.
There can be one situation because 164, one of the witness have stated that he had enticed her daughter. I mean, leaving aside last in theory, he had not come that night. And he said that he had enticed his daughter on that particular night, and his daughter left with all money and ornaments. So there can be a situation she was at home of the accused, and then accused was calling her. There can be one because there are phone calls.
Let us see the 164 statement.
164 Lordship will see of
Page.
anyway, that has not corroborated the main evidence. One of the witnesses I found
It's a-
saying this. Yes, this is page 87. He is the father, PW1. He of course did not say about his coming that night at 9 o'clock. What he said, Lordship got page number 87.
Yeah.
On the night of 3-2, my boy, the boy by the name Babu, took my daughter Anisa away by enticing her. On not finding my daughter in the house in the morning, we started searching for her.
This is on 3/2/2013.
3/2/2013 in the night. Now-
So if this is 3/2,
Incident had occurred on 3/2 only. Matlab the intervening night between 2/2 to 3/2.
you see, because now then when we go to page 26,
Hmm.
this CDR, this phone calls,
Huh.
they were made with respect to 2/2/2013, With
In
the-
the
with
last
the-
paragraph,
with the intervening night of 3/2/2013.
Huh.
So all these calls were made prior to 9 o'clock, prior to 9 o'clock of 3/2/2013.
no, Lordship will see the last paragraph. On 3/2, call was made at 1:24 AM. So
Where?
this is midnight.
Where on 3?
Last paragraph of page 26. So on 3/2, call was made at, so perhaps this is intervening night of
On
2/2
3/2,
to
where are
3/2.
you reading on 3/2?
The last paragraph,
Last paragraph is on 3/2, call was made at
Uh,
1:24 AM.
1:24, this is midnight.
Ah.
So this is past 9 o'clock perhaps.
Yes.
And
No,
the call-
no.
Huh?
If it is 1:24 AM, it will be the next day. It will be 4.
So,
You see, 1:24
Huh.
AM
hmm,
will be
huh,
prior to 9 PM.
4.
Madam,
Huh,
when we say 1 AM,
hmm,
it means last night.
last night, yes.
It doesn't mean that night that is going to come.
No,
So this, you see, so this person had gone to the house at 9 PM of 3rd. Calls were made
prior
at
night.
1:24 AM. That means prior to 9 PM, because that 1 AM will start from 12 midnight of 2.
But I doubt these people are so precise with
No, but
the,
anyway,
date,
this is what is
because-
the, this is what has been reflected. Now, we
because
go-
in the previous paragraph, exhibit 12 is the CDR of 2/2 with intervening night of 3/3.
correct,
So perhaps from 2/2 to 3/2.
ah,
Huh,
correct,
3/2.
3/2,
So 1:24
yes.
can be of 4th of February.
No, cannot be. How can it?
But I doubt these rural people will be so precise in saying that on
Well,
4th,
but then how can we presume that?
we cannot presume.
And
But
then we,
normally what we don't count the way, I mean, from 12 o'clock and we say it is
But
the
when-
next day.
but
Sometimes-
when they are so precise, we
Huh.
have to be precise also. We cannot say no, that it has to be presumed to be this.
That of course, we cannot presume anything.
So these calls were made prior to 9. So this has got no meaning.
But enticing, what I'm on is
Okay,
But-
here entice.
Huh,
But where is-
entice
where-
took
where is-
her.
But where is the proof?
Huh. And the last line, Lordship, you
Uh,
see, must see,
Huh.
last line of this 164,
Page
87,
87.
page 87.
Yes,
My daughter had taken along the money and the gold remaining in the house with her. So what this implicates is that implies is that she had gone gone out from her matrimonial house,
but
from
this,
her
but
parents' house.
this has not been stated in the evidence.
This has not been stated. 164 at best corroboration,
This has not been stated.
not stated. So if there are contradiction as far as his coming at 9 is concerned. So that goes. And this is a case where there is no ocular evidence, so we will have to rest it on circumstances. Circumstances, if we see, there is relationship between Babu and the deceased daughter.
Now, you see, there is a problem.
Hmm.
You come to page 76.
7 and 10.
Who is this Masoom Khan, PW?
Masoom Khan
PW
is-
two, madam. He's a cousin brother.
PW
He's-
two.
He says on 2/2/2013, after coming back from
Ah.
campaigning, I retired to bed at 11.
Yes.
Then my uncle came and informed that Anisha was missing from the house.
This is what I'm saying. They are referring to the 2-2. 2-2 to 3-2, not 4-2, which actually should be. This is the previous day. After getting up, so she was missing in the intervening night of 2-2 to 3-2,
Supposedly.
perhaps.
Let us see the evidence again. PW1.
Huh.
No
PW1 said,
date.
huh,
PW1, no date.
no date.
No date. PW2 also no date. PW2 also no date.
Hmm. On the day of occurrence, what they are saying is,
PW3 states
hmm,
incident took place on 2/2.
hmm. Yes, the incident took place on
PW2.
2-2.
Three stated it was 2-2. Actually, the evening that was 2-2.
2-2. So 9 PM of 2-2.
So affair was lost
9
on
PM.
third. That means next day
But
morning.
then 9 PM of 2/2.
Hmm.
So then the four
Thing.
calls could have been made. Then.
Then they matches.
Then the date match.
Hmm. Then it was late night.
Now let us see what the police say. But when was the FIR registered?
Next day,
FIR
that
was
is-
next day, 3-2,
3-2.
12:10 PM.
Okay, 3/2. Then it matched.
Hmm. So alleged 9 PM was of 2-2 when Babu came to their house, but then that is contradicted.
Hmm?
Contradiction is proved.
What?
That he did not come on that night, 9 PM. Nobody had said this.
Yes, nobody had said.
So that contradiction stands proved.
Yes.
So that goes from this chain of
So there's nothing to prove that the Babu had come to the
that
girl's house
night,
that night.
because all the 4 witnesses have contradicted.
They have not said anything in the 161.
164 only father said on that night he enticed her and took her away. And she had taken her jewelries. And this is not there in
This is
the
not there in the
the-
evidence.
substantive evidence.
But anyway, for contradicting a witness. Okay, the witnesses were not contradicted, only the IO clarified the issue. That's all.
It was as VK Mishra's case, as it is provided, this has been properly done. It was brought on record. And when it was produced before the respective witnesses, then it was proved through the IO.
No, it was not brought to the notice of the witnesses.
No, it was brought. They said
brought.
that I have not stated.
But that's it.
It
Oh.
was brought. Lordship will see. PW1,
Fair.
page 10, last paragraph. It is
Ah.
not a fact. Here, I think PW1 had not stated in so many terms. Lordship will see, it is not a fact that it was not mentioned. This is not required. Then it is not a fact that I stated to police that I suspected. This is not required. This is not a fact that I stated. to
Okay, it
police.
is not a fact that Raju's visit, his watching TV with Anisha and the departure to have a walk are false statements.
Are false statements.
Okay.
No,
that-
he did not say that it is not a fact that I have not stated before police.
No, he said that it is not a fact that Raju's visit He's watching
It is-
TV, Tanisha, and the departures to have a walk are false statements. So he has been basically.
Not in
true.
so many words,
Not
but
so, but yes,
statements means 161.
yes, yes,
It is not a fact that Raju's visit
are
his-
false statements.
are false statements. Then it is proved through the IO.
Yes.
PW two also Lordship will see. Two, no, not two, 3 and 4. 3 also had stated. It is not a fact that I did not state to police that I had seen Babu coming to our house and having a conversation with Anisa. Then 4 also.
Okay.
But then, four confirmed,
Hmm.
160% from the four confirmed that, she stated in 160, she was sleeping. And in the morning, she found.
Ah, that is there. in
She was
164.
sleeping 11, no, just a minute, yes. 4, what does she say? And. so-
4,
so-
page 18.
I have a 4 now, it's
And last paragraph, page 18. 18. It is not a fact that police questioned me and I neither stated to police nor in exhibit 5 that Babu was talking to Anisa and I was so and so.
Where, page 18,
Last paragraph, page 18.
it is not a fact.
It's 19.
Oh, it is magistrate. Police also there is contradiction. Uh-huh.
At about 11 PM on the previous day of the incident, I replied back of watching TV in the room of Anisha. Anisha also replied back, depending upon the voting day, upon the Anisha was available.
So he denies his.
Which page?
Page
One
19. also. Page 19,
Ah,
it has been put to her. And to see exhibit 5,
ah.
164
Exhibit 5 is the 165 statement,
164 statement.
164 statement of PW4, PW2,
PW4.
PW4.
Here he
Exhibit,
denies-
exhibit 5.
Here he denies his 164 statements. It is not a fact that I stated to the magistrate in the following manner.
And in any event, the 161 statement is not,
161, Lordship will find the last paragraph of page 18.
okay.
So all these 4 witnesses have stated that they have not stated before the police that Babu came that night. And it was proved through the IO. But one fact, but phone calls were there, but the certificate is not there. We
No, but-
cannot again
no, but
rely.
then phone calls, what do they prove? Phone calls prove nothing, even if they were there,
Yes.
they prove nothing. It only reinforces in a way that they
Yes.
were not in contact with each
Not
other.
in touch.
Naturally, there's no question of your girlfriend and you sitting side by side and walking and talking through a phone.
No, why I'm saying is there can be a situation she went to their house and the accused made phone calls from outside. This is again presumption, of course.
That was the
So Lordship, what?
1001.
Oral evidence of are you going to get into the CDR also?
What oral evidence of?
Are you regarding the CDR? Because CDR has not been proved as per the law.
Serial 65 B.
So whatever he said in but orally. it is not
No,
applicable
in
section 59.
any event, even if there is a phone call made between them, how does it matter? They might have talked, they might have not have talked, we do not know how, what is the, how do you connect that CDR with the crime?
And Ziploc, of course, police said that we could not identify, but PW number 2, which he did not read, PW 2 has said that it belongs to Ziploc belongs to the jacket, it had come from the jacket which belongs to the accused.
Then it is-
Lordship,
Again, it is contradiction.
there is, yes,
How?
there is contradiction.
This part that it belongs to the accused, is so. It is
Were
contradictory
not
statement.
stated.
It has been put to the PW is true and confronted with the INO.
That, yes.
Where is that?
That is there. I forgot. This is page 13. No, not page 13. Yes, page 12, last sentence, last but one sentence. It is not a fact that I did not state to police that lock chain was found in the hand of Anisa. It is not a fact that I did not state to police that I had seen Babu wearing the jacket and that chain lock was of Babu's jacket. So this is brought on record. Then proved through the IO
Page,
29.
29.
Witness Masum did not state to me that lock chain was of jacket of accused Babu, that it damaged SIM card so and so. That it lock chain was of that jacket and that 2 months so and so. Yes, that contradiction is also true. So here, no ocular evidence, so we will have to rest it on circumstances. So circumstances, if I just see, barring, leaving out all those contradicted parts, there was a relationship between Babu and the girl. Father and daughter were at home that night. Brother and the sister-in-law were staying in a way separately. Then, yes, separately. Then, night she went missing. On 3/2 night, she went missing. Morning, her body was found in the field. Homicidal death, strangulation. This is what the doctor said. Homicidal death. Then, his conduct, Babu did not come to inquire, father said. They were having a relationship. He knew that she died. Perhaps he didn't come, that I cannot say. But
no, we do not know. Anyway, yes,
threatening part is there from the respondent
Yes.
side.
there's a possibility only.
Ah.
There's a possibility that Babu's family might have done it.
Hmm.
But that is a possibility, that's all. So suspicion, presumption, we do not know.
And there will be a,
Because there was no occasion for Babu to kill his girlfriend.
because he was adamant in marrying
He
one
was
of the
adamant in
witnesses.
marrying her. So where is the motive to kill her? Especially when there is no witness, eyewitness.
The chain does not become complete. There is a
There's no
gap.
chain. I mean, there's no
Mhm.
chain at all. And the question of the threatening,
Hmm.
the threats made by the boy's family relates to a period of 4-5 months back,
Yeah, 2 months also.
2 months also.
But there is a, there is a contradiction again
Which they did
regarding
not, which did not act upon at any time.
threatening also. There are some
And
contradictions.
despite the same, Babu was still adamant to marry her. So why should he kill the love of his life?
Hmm.
That is also there. So I mean, it is a possibility, but where is the proof? We cannot. So what is wrong with the judgment? I don't know.
Judgment went on only one aspect, that last scene was too long. So
last
he did
scene was
not
too long.
believe.
So it did not go into all these
Ah.
aspects. So this is more, I mean, more clearer now.
Learned trial court didn't go into the contradiction. The last scene theory actually goes.
Last scene theory go, there's no last scene at all.
No last scene at all.
There's no last scene at all.
And there is, I don't think, these are, I don't think so.
Okay, where is the last scene theory? Where does the trial court
Ah,
speak
yes.
about it?
Well, the
Page
page 66. Last paragraph.
On scanning the evidence. It reveals that none has been able to say that they saw the occurrence except the last scene theory. That is to say, on that evening, Aisa went with the accused.
Anyway,
This also actually goes.
this also there's no.
Then they say last scene theory is not a mantra that can be used in each and every case.
Your case was basically last scene theory.
Mainly merit and circumstantial also.
What's about it?
There is a law affair
Huh?
and threatening and.
Who threatened? Babu didn't threaten. Babu never threatened his girlfriend.
Babu knows about it.
Then,
That's
but
the family member.
you are saying Babu killed her.
But here succeeded to all the family members.
Maybe,
And
but
they are also
Babu never
died.
threatened her. Okay, right. Heard Mr. Enuddin, learned counsel for the appellant. Also heard Miss S. Jahan, additional PP for the state of Assam. And Mr. S.D. Purkaista, learned counsel for the respondent number 225. Yes, sir. This appeal has been filed by the informant,
Yes, madam. PW one.
bracket, prosecution witness number one. No, don't say bracket, slash prosecution witness number one, bracket PW dash one. Against the impugned judgment dated 16/5/2016, passed by the sessions judge, by the court of the sessions judge, Golpara, in sessions case number 213/2030, acquitting the respondents number 2 to 5 from the charge under section 302/34 IPC on grounds of benefit of doubt, in the killing of one Anisa Khan, ANISA Khan, who is the daughter of PW1. Next paragraph. The
Begum.
Anisa Khan, huh?
Somewhere Begum also, in affair Begum, Anisha Begum.
Anisa Begum, alias Anisa Khan.
Yes, ma'am.
Because in the judgment, the mentioned, actually Anisa Khanum also.
Yes, ma'am. I-
Anisa Begum, Anisa alias Anisa Khan,
Somewhere
alias Anisa
Khanum also.
Khanum, KHANOM,
Yes.
daughter of PW1. Next paragraph. The basic, the learned trial court in the impugned judgment had acquitted the respondents number 2 to 5 in relation to the death of the deceased Anisa Begum, on the ground that there was a long gap between the last seen theory wherein the respondent number between the last seen theory between the respondent number, Babu is respondent number 2, and the deceased no, just the last in theory between the respondent number 2 and the deceased and the death of the deceased. Full stop. The learned counsel for the appellant, next paragraph, the learned counsel for the, no, continue, the learned counsel for the appellant submits that the respondent number 2 and the deceased who were in love, had gone out from the house of the deceased after 9 p.m. on the night, on 2013. And as the respondent number 2 was the last person to have seen the deceased alive, comma, it could only have been the respondent number 2 who had killed the deceased, comma, with the possibility of the other respondents who were the relatives of the respondent number 2 being involved in the same. Yes. First one. Being involved in the death of the deceased. He also submits that the circumstantial evidence in the case only points to the involvement of the respondents in relation to the death of the deceased. Full stop. As such, the impugned judgment should be set aside. And the respondents number 2 to 5 should be convicted. And should be convicted under section 302/34 IPC and sentenced accordingly. Next part. The additional PP and the counsel for the respondents number 2 to 5 submit that on a careful perusal of the records, comma, there is nothing to show that the last seen theory would have been applied to the case of the respondent number 2. Comma, in as much as there was no evidence, there was no proof. In as much as the evidence of the prosecution witnesses was contradicted by the evidence of the IO who had denied, who had stated that the prosecution witnesses had not told him in their statements under section 1616 CRPC that the respondent number 2 had gone to the house of the deceased at around 9 PM on 2/2/2030 and left with the deceased on the said night. We also submit that the other circumstantial evidences, that we also submit that the circumstantial evidence, they submit that there was no link in the circumstantial evidence to form a complete chain showing the involvement of the respondents number 2 to 5 in the death of the deceased. That's all. We have heard the learned counsels for the parties this time. The prosecution case in brief is that An FIR dated 3/2/2013 was submitted. At what time?
FIR no time, night. FIR is 12:10 PM. Occurrence only night,
12:10 PM?
PM.
How can they be 12:10 PM?
No, FIR is 12:10 PM, after 12 o'clock daytime.
Acha, 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 acha. So it will not be 12:10 PM, it's a 12:10 noon.
Noon, huh?
Yes, ma'am, noon. 12:10 noon,
At 12:10 noon,
132.
12:10 noon. By PW1, who is the father of the deceased, Anisa Begum. He states in his FIR that his daughter Anisa Begum was having a love affair with the respondent number 2 for about a year. However, his daughter was brutally killed 100 meters away from his house, and he suspected the respondent number 2 to have committed the said crime. In person to the FIR, Krishnai PS case number 23/2013 under section 302 IPC was registered. After investigation of the case by the investigating officer, the charge sheet was filed as the IO had found a prima facie case under section 302/34 IPC against the respondents number 2 to 5. Next paragraph. Charge was framed against the respondents number 2 to 5 under section 302/34 IPC, to which they pleaded not guilty and claimed to be tried. Thereafter, thereafter, 8 prosecution witnesses were examined by the learned trial court. And examination of the respondents number 2 to 5 was undertaken under section 313 CRPC, in which they gave a denial, in which they denied their involvement in the death of the deceased. The learned trial court thereafter, by the impugned judgment dated 16/5/2016, came to a finding that in view of the long gap between the time period of the respondent number 2 and the deceased having gone out from the house of the deceased, and the possibility of other persons coming in between having existed during the said time period, comma. It would be hazardous, it would be hazardous, 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 to come to a conclusion of guilt against the respondents, number 2 to 5. It also held that as there were no eyewitnesses to the occurrence of the murder, and in the absence of the exact time of death and the time of last seen together, last seen together without the exact time of death and time of last seen together, comma. The last seen theory could not be applied to the facts of the case. Last seen together theory could not be applied to the respondents number 2 to 5. 2 to 5 or 2 to 6? 2 to 6. 2 to 5. 2 to 5. It also held that 2 to 6.
There are 5.
It also held that mere communication between the accused and the deceased over phone prior to the death of the deceased was not enough to hold the respondents number 2 to 6 as being guilty of the crime. The learned trial court thereafter acquitted the respondents number 2 to 6 from the charge under section, excuse me, all the next step. Under section 302/34 IPC. By coming to a finding that the prosecution had failed to establish its case beyond all reasonable doubt, and by giving them the benefit of doubt. Full stop. Next paragraph. A perusal of the evidence given by PW1 bracket father of the deceased, comma PW2 cousin brother of the deceased, bracket close, comma PW3 brother of the deceased, and PW4 sister-in-law of the deceased, comma, is to the effect that the respondent number 2 who was in a love affair, who was in a relationship with the deceased, had come over to the house of the deceased on 2/12/2013 at around 9 p.m. And they had left the house together on the night of 2/12/2013. Yes, come. Huh? The as the deceased did not return home, continue with that. As the deceased did not return home to her house, comma, a search was made for her, and her dead body was found lying in a field. The evidence of PW 1 to 4 is also to the effect that a lock chain, huh? Bracket zipper slider. Right, clothes. Which was a part of the jacket worn by the respondent number 2. Was held in the hand of the deceased. Further, there were injuries on the head and hands of the deceased. And that a red and black chador had been tied with knots in the nape of the neck of the deceased. A SIM card was also found beside the dead body. Along with a red ribbon and a high neck sporting t-shirt and a high neck red sporting t-shirt. Thus, who is 5, by the way? PW 5?
Hearsay witness is.
Okay, is a hearsay.
Morning he came in.
Huh?
He came morning, when the.
Later on, later on. So he's got nothing.
Earlier, he has no knowledge.
He has got no role.
So yes.
Yes. Next. The basis for, next para, the basis for the appellant's counsel stating that the respondent number 2 was involved in the murder of the deceased is due to the last seen together theory, keeping in view the evidence of PW 1 to 4, which is to the effect that the respondent number 2 and the deceased had gone out together on the night of 2/12/2013, and that was the last time the deceased was seen alive. Next one. The learned counsel for the, no, the further stand of the appellant that the respondents number 3 to 5, 3 to 6 were involved in the no, could be involved. It could be involved in the murder of the deceased was due to the evidence of PW 124, which is to the effect that the family of the respondent number 2 were against the relationship between the respondent number 2 and the deceased, and had apparently threatened PW1 that they would kill the deceased if she ever went to the house of the respondents number 2 to 6. Next paragraph. The evidence of PW5 is to the effect that is hearsay evidence and does not have much relevance in deciding the case in hand. Next paragraph. The evidence of PW6, who is the senior medical and health officer, Valpara Civil Hospital, is that he performed post-mortem examination on the dead body of the deceased. And he found, and his examination was, no, and that his opinion on the cause of death was due to asphyxia following strangulation by a sheet of cloth which was ante-mortem in nature. Page 23. Post. The evidence of PW7, who was working as a bench assistant in the court of the Judicial Magistrate First Class, is that she recorded the statement of PW, recorded the statement of PW1 under section 164 CRPC. Only one. Not in this page 24. Only one. Only PW1. 164 CRPC. So that PW4's CRPC statement is not relevant. How can, so no judicial officer was examined
But PW4 himself. no? I can't. Exhibit 5. He said page 18.
Yeah, yes, yes.
He has proved it.
Okay, next.
Perhaps one had not proved.
Um,
One of those.
Acha, before that, no? In just say, in the, when was, I'm talking about 1 to 4. Just right. PW4 in his evidence has exhibited his statement given to the magistrate under section 164 CRPC as EXT 5. And EXT 5 bracket 1 and EXT 5 bracket 2 as his signatures. Then you come back to it. Next para. In the statement made under section 164 CRPC by PW1. Comma. PW1 has stated that on the night of 3/2/2013, the respondent number 2 took his deceased daughter away by enticing her. He also states that respondent number 2 and his daughter had been in love for 1.5 to 2 years. And that about 4 months back, the respondent numbers 3 to 6 had threatened him that they would kill his daughter if respondent number 2 were to take her to their house. He had further stated that his daughter had taken along money and gold remaining in the house with her. Next para. PW4 in his statement made under section 164 CRPC has stated that on 3/2/2013, the deceased was found dead in the field. And they were supposed to get, she was supposed to get married with the respondent number 2, with whom she was in love with. On 2/2/2013, they had retired to bed at about 11 p.m. after watching TV. The deceased had also retired to bed. However, the following day, they didn't find the deceased in her room and thought that she had eloped with the respondent number 2. Full stop. However, they found her dead on the field. She also states that, now PPW4 also stated that the mother and brothers of the respondent number 2 had rebuked them, saying that they would not accept the deceased as their daughter-in-law. PW4 also stated that the deceased had been raped and killed, raped and killed. Next paragraph. There is a contradiction with the. No, just. There is, in the statement made by PW4 under section 164 CRPC. There is nothing to show that. The respondent number 2 had come to the house of the deceased on 2/2/2013. Or that PW4 had seen the respondent number 2 and the deceased going out of the house of the deceased together. However, in the evidence given before the learned trial court, PW4 had stated that at about 7/7:30, respondent number 2 had come over to their house and started having a conversation with the deceased. After a while, respondent number 2 and the deceased went out of the house saying that they would go out for a walk. At about 9:15/9:20 PM, respondent number 4's husband came back from the market. And after having dinner, the PW4 locked the door. Locked the door. On getting up at 5:30 AM, PW4 found that the deceased had not returned home. And on a search being made, they found her dead body in the field. Full stop. As can be seen from the above, statement made under section 164 CRPC by PW4 and her testimony before the trial court, comma, there is a contradiction in her statement. Full stop. The PW4 in her cross-examination was confronted no, full stop. No, don't say that. The above being said, comma, next para, the above being said, PW4 did not tell the police in her statement under section 161 CRPC that the respondent number 2 had been talking to the deceased and that they had gone out of the house together. First step. This discrepancy in the statement made by PW4 under section 161 CRPC and her testimony during examination in chief before the trial court was put to her, wherein PW4 states that now, wherein PW4 denies the suggestion that denies what suggestion that the denies the suggestion that the police did not question her or that she did not state to the police, nor in Exhibit 5, that she saw respondent number 2 and the deceased having a conversation in their house and them going out together on the fateful night. No, they're going out together. First up. The statement made by PW4 in her the PW4 was also confronted with her statement made under section 164 CRPC with regard to PW4 retiring to bed at around 11 PM. And also stating that the deceased had retired to bed. Next para. This discrepancy in the statement made by PW4 under section 161 CRPC and 164 CRPC vis-a-vis her testimony before the learned trial court was also put to the IO bracket PW8 during a recording of his evidence. Comma. PW8 stated in his cross-examination that Nandit Bihar.
Page 29.
That PW4 did not state that respondent number 2 and did not give him a statement to the effect that the respondent number 2 had come to their house and had conversation with the deceased, or that they had left the house together. PW8 further denied, that PW4 had stated that the respondents number 3 to 6 had stated that they would not accept the deceased as their daughter-in-law. Next, Kara. The statements made by PW 1, 2, and 3 under section 161 CRPC also does not speak of the respondent number 2 coming into the house of the deceased on the night of 2/3/2012. Is it 2/3/2012? 2/2/2013. 2/2/2013. Or the respondent number 2 and the deceased leaving the said house together for a walk on the said night. Correct? Yes, sir. The contents of the statements made by PW 1 to 3 under section 161. No, this is like this. Cut that. This is PW 1 to 3 were thereafter confronted with the statements made under section 161 CRPC, as they had stated otherwise in their testimony before the learned trial court, wherein they stated that respondent number 2 had come to the house of the deceased and had left with the deceased for a walk on 2/2/2013. However, as in the case of PW4, PW8 in its evidence has denied that PW 1 to 3 had given such a statement to him under section 161 CRPC. Further, the contents of the statement made under section 164 CRPC made by PW1 with regard to the deceased carrying away money and gold never does not find mention in the evidence adduced by PW1. Full stop. The fact that the fact that PW 1 to 4 have been confronted with their statements made under section 161 CRPC, which is not in sync with the evidence recorded before the learned trial court regarding respondent number 2 having come to the house of the deceased and taken her out for a walk on the said night. Shows that they are unreliable witnesses. In the case of V.K. Mishra and others versus State of Uttarakhand, 2015, 9 SCC 581. You have got the judgment with you. The apex court has held that a witness should be confronted with his previous statement before the police under section 161 CRPC to contradict what state of Uttarakhand? To contradict his statement at the time of recording of his evidence, to discredit the witness. Section 145 of the Evidence Act also provides that a witness may be cross-examined as to the previous statements made by him in writing or reduced in writing or reduced into writing, and relevant to matters in question, without such writing being shown to him, comma, or being proved, comma, but, comma, if it is intended to contradict him by the writing, comma, his attention must, comma, before the writing can be proved, comma, be called to those part of it which are to be used for the purpose of contradicting him. There, the apex court further, the apex court in VK Mishra Supra further held that thereafter, when the IO is examined in the court, his attention should be drawn to the passage marked for the purpose of contradiction. In the case in hand, comma, PW 1 to 4 have been confronted with their statements made to the police under section 161. And the IO has also been examined in court by drawing his attention to the contradiction in the statements of PW 1 to 4 made under section 161 CRPC and their testimony before the learned trial court. As it is clear that the question of respondent number 2 coming to the house of the deceased on 2/2/2013 and taking out the deceased for a walk on the said night was never a part of their statement made under section 161 CRPC. Comma, but has appeared for the first time in their evidence recorded before the learned trial court. Comma. The it cannot be said that respondent number 2. It cannot be said that the question of the respondent number 2 having come to the house of the deceased and taking out the deceased for a walk on 2/2/2013 has been proved. In that view of the matter, comma, we are of the view that even the last seen together theory would not be applicable to the facts of this case. Consequently, we do not agree with the finding of the learned single judge, with the learned trial court, that the learned, that the last seen together theory would have been applied to the facts of the case during trial. As there is no evidence, first up, next paragraph. The above being said, comma, there is nothing to prove that the chain lock, the chain lock or lock chain, bracket zipper slider, bracket close, huh? That is in page 12. Huh? Found in the hand of the deceased was a part of the jacket worn by the respondent number 2. This is fortified by the evidence of PW2 in his cross-examination, where he states that he did not no, is it? No. Where is that?
Contradiction.
Yes. No,
Page 29.
page 12. Page 12, no? Is it that it is not a fact that I did not say Dr.
Babu wearing the bag.
But he said, but this is against, where's the contradiction?
That is a page 29. Police has, it is
Ah. What have I said? It is fortified by the contradiction in the statement made by PW2 in his cross-examination, which has not been supported by the evidence of PW8.
second paragraph.
And wherein supported by respondent number, wherein he states that, wherein PW8 states that PW2 did not state that the lock chain belonged to the jacket worn by the respondent number 2. Anything else? Nothing else. I've covered everything. Next para. On
Here aspect it is required.
ha. Next para. There is one aspect of the matter which has also been pointed out by the learned counsel for the appellant. That is with regard to the CDR will be the full form,
Call data records.
call data records, with regard to the call data records, bracket CDR. Of the respondent number 2's mobile,
Call detail record.
for detailed records of the mobile of the respondent number 2 made to the mobile of the deceased. Full. There is nothing to correlate the calls with the death of the deceased. And in any event, there being no certificate made with regard to the said CDRs in terms of section 65 capital B of the Evidence Act, Indian Evidence Act, the said calls in any event would not have any relevance to the facts in issue. Correct? Huh? The would not be admissible in the evidence.
Anwar Bashir.
Bashir's case. Paragraph 14. In the case of so and so were reported in 2014-10 SCC 473. The the Honorable Supreme Court has laid down the conditions required for admissibility of a document depending upon the satisfaction of the four conditions laid down in section 65B bracket 2. 65B, just 65B of the Evidence Act. As there is no certificate made in respect of the CDR of the alleged mobile and of the mobile belonging to the alleged respondent, belonging to the respondent number 2. The said CDR is inadmissible as evidence. Yes, it cannot be used as evidence. In view of the real state above, we do not find any ground to interfere with the finding of the learned trial court that the prosecution has not made out a case. No, no, in acquitting the respondents number 2 to 6 from the charge under section 302/34 IPC. The appeal is accordingly dismissed. Send back the LCR.
Sassoon customer may be reflected.
Huh?
Sassoon customer may be reflected.
We have said in the very beginning, we have said. 9 and 12. 9. 12 is what? NJ Das.
12 is yesterday's matter.
May I pray for 26th, madam, because I will be out of station.
Okay, what was that? Yesterday's matter meaning?
Yesterday's matter where there are eyewitnesses
It may calm down, my lord.
for, bike accident and the lady was carrying the grudge and then while she was coming back from a neighbor's place, the person hacked her on the head. Because of him, her son died due to a bike accident.
Taunting remarks made by the, my lord, deceased.
All right, okay, when? When do you want?
26, my lord. Kindly, well.
On the prayer of the counsel for the appellant.
My lord.
This is the matter on 26. That is item
12, my lord.
12. And what, okay, 9th on,
9
it come?
is father sexually abusing his own daughter. Section 4(6). Bhagavati is not.
what to do? Let them list whenever.
Lots.
Now, I think we have passed the time limit. Huh? Oh, it's still 4:30. It's still 4:30. Oh, we still got 10 minutes. Okay, Madam a single way.
Oh,
Okay, right. As no one appears for the appellant, item 9. This is the matter after a week.
obliged. Single bench আছে? Single bench আছে? Oh, judgment. তুমি বেশ তুমি বহুত জটিল আছে নুঠে কি পৃথিৱীৰ নহয় আছে জানা পৃথিৱীখন পৃথিৱীখন